Good morning, everybody. Happy Friday. Welcome to the Courtroom Files Live, where I'm officially declaring that Friday is once again Friday. It's no longer Wednesday, or however that worked. But let's have a great day today. We'll start out with Judge Glazer. Let's see what's going on in her world.
In the event there's an open case in dependency court, any and all orders entered in dependency court regarding your contact, visitation, and custody shall supersede or replace this court's order. State what bond do you want? She lives in Georgia. 2,500 and
She's got a fugitive holds.
Yes, from Palm Beach County, no bond.
All right, so count one, child neglect with great bodily harm is a $5,000 bond. Count two, child neglect, no great bodily harm is $2,500. Good luck to you, ma'am. Next we have is Harry Dodd Velez. Mr. White's trying to reach us. Mr. White, I don't know. Did you promote him?
I'll try again.
I don't know. I'm not going to deal this. You raise your hand, you got to leave it raised, or I got to search for you on Zoom. It's like playing a game of, what is it called? Like whack-a-mole. You can't find where you are. Okay. Mr. White, how can I help you, sir? I have a busy calendar. I'm happy to address it. Okay, next case is Caridad Velez, page 4. Good morning, ma'am. You were arrested for aggravated battery with a deadly weapon. I will appoint the public defender's office for you.
She stabbed the victim in the hand, causing a deep laceration. I do not have the victim's name.
All right. There's probable cause for aggravated battery. You are ordered to stay away from, I don't know who the victim is, stay away from him. I think it was like a road rage incident, maybe, I don't know.
So it was charged as an F2. I think there may be probable cause for the F1, requesting $15,000. If you're
No,
only
there's probable cause for an F2. How was it an F1?
a deadly weapon with SBI. She did 364 for Bergbat in 2022. I see other prior violent convictions, including a prior prison sentence for armed robbery.
Bond is $7,500. Have a good day. Stay away from whoever the victim is. Mr. White, what can I do for you, sir? I promoted you. You have to accept the promotion. You can talk. What is it? Driving me cuckoo.
Judge, thank you for taking me out of turn. I had some technical difficulties.
Oh,
I'm
I
here
see.
on the case of Rolando Ravelo. This is a case that you set the bond on Wednesday, and now Friday, correction still doesn't have clarification.
He has a Nebbia hold. That's why I asked yesterday. They said he's trying to post his bond, I think, and he had a Nebbia.
No,
No,
Judge,
he has no Nebia hold.
Oh, but he said he posted his bond, right?
we posted, but corrections isn't releasing him. They're making me go back to court to get clarification for I don't know what.
Corrections, wait, because Ira sent me this yesterday and I thought I dealt with it yesterday. Let me see. Corrections is jail numbers, I have it here, 250-154-072. Mr. Ravello,
Okay, Your Honor.
so what's
we'll
going
get it.
on?
So corrections, I guess, is gonna research it, get back to us.
Judge, I-
Just take a second, they did it yesterday.
yeah, I believe because there's some crimes charged and some accompanying citations, they may not have the bond amounts for the citations, is what my guess is.
I don't know. Is he being held by me? I gave him a bond.
Yes, you did, Judge.
Any luck, corrections?
And Your Honor, we need to look for the car. You're gonna get, please give us a few
They have
minutes.
to go get the jail card, sir, sit tight. Now we have Jessica Bonfima Kuna. Good
You may
morning,
qualify
ma'am.
for TAP.
Ma'am, you were arrested for possession of crystal meth, a controlled substance, and possession of drug paraphernalia. Do you speak English?
Spanish,
Little
please.
bit.
Spanish preferred.
Yana, could you repeat? I'm sorry.
You were arrested for possession of a controlled substance called crystal meth and possession of drug paraphernalia.
Buenos días, señor. Usted está aquí enfrentando acusaciones de haber estado en tenencia de una sustancia regulada, dígase cristales de metanfetamina, y además de haber estado en tenencia de adminículos para consumir drogas.
I will appoint the public defender's office for you.
Le asigno el abogado de oficio para que le represente.
You know, yeah. All right. Anyways, how long have you lived in Miami?
¿Cuánto tiempo lleva viviendo en Miami?
Como 10 años ya.
Around 10 years already.
Do you have an address where you live?
She's currently
¿Tiene una
home.
dirección donde vivir?
Ahora estoy sin casa. Estoy home.
I'm homeless right now.
Tap alternate bond, $2,500, count one, $500, count two.
Muy bien, señora. Entonces le vamos a dejar salir con supervisión del programa TAP y alternativamente fianzas de 2,500
You
en
have-
el caso 1 y 500 en el caso 2.
You have to come to court for your arraignment on, I'm sorry, October 6th at 9 a.m., courtroom 24.
Señora, tiene que presentarse en la sala 2-4 del edificio de justicia penal Richard E. Gerstein el día 6 de octubre a las 9 de la mañana para la lectura oficial de cargos.
Have a nice day.
Tenga buen día.
Your Honor,
Yes, ma'am.
for the attorney on Ravello,
Yeah.
that the problem was not with bond hearing, it was with a traffic case. And they're addressing that case this morning in jail
Wrong
arraignment.
courtroom, 5-3. Go see Judge Capote.
Judge, you set the bond on the case already. They just didn't write it down. There was no, I mean, you
It
said
has
it.
nothing to
Traffic?
do with a felony. Nothing to do with a felony. It's a traffic case that they're addressing whatever issue they have in jail arraignment this morning.
Okay. Thank you.
Next is Christina McDuffie, page 4. Hi, Miss McDuffie. Good morning.
Hey, good morning.
Ma'am, you were arrested for driving with a suspended license, third or subsequent conviction. I will appoint the public defender's office for you. So it looks like there's probable cause for the charge. She keeps pick driving and she doesn't have a license. You got to get it straightened out, ma'am. You're out on bond. There's a hold for F-25 13948 and F-25 239-5B. Anyway, I'll set a bond. What do you want me to set it at? I feel bad for her. She needs to get a license. She has to drive to get her kids. You can't drive to pick up your kids until you get a good license. $1,500, no driving unless you get a good license, ma'am. Next,
Good morning once again, everybody. Welcome to the Courtroom Files Live. And again, happy Friday to all of you. We're going to hang with Judge Glazer for a little while. It's a little bit slow to kick off every place else this morning. Most of the action is either landlord, tenant, or stuff that's super pedestrian in nature. So this is the best bet. But we'll move on as other things come online.
Buenos días, señora. Usted fue arrestada por fraude a un seguro por el haber hecho un accidente ficticio.
Conspiracy to commit an organized scheme to defraud,
Además, por confabulación, por haber creado una confabulación de fraude.
and false report of a crime to law enforcement.
Y además de haber denunciado un delito falso a la policía.
I will appoint the public defender's office for you.
Le voy a asignar al abogado de oficio para que le represente.
So
There's
she was a
prob-
passenger in a staged accident. She was supposed to receive $1,000.
I'm sorry, counsel, you said she was a passenger at the beginning of
Passenger.
the statement?
In a staged accident, and she was supposed to get $1,000 for her participation.
Muy bien, se indica acá por parte de la fiscalía que usted era una pasajera en el accidente ficticio y se suponía que recibiese $1,000 por haber participado.
Anyway, there's probable cause for the charges.
Tenemos motivo fundado para las acusaciones.
I'm
Judge,
setting up.
would you consider program pretrial services, Judge?
Is there a bondsman here on this one? Somebody's raising their hand.
Ma'am, how long have you lived in Miami?
Entonces, la defensa había pedido algún programa para dejarle salir con el programa de servicios previo a juicio. La fiscalía pregunta si existe un fiancista presente para este caso y su señoría le pregunta, señora, ¿cuánto tiempo lleva usted viviendo en Miami?
2 años. 2 years. 2 años.
2
Okay,
years.
all right. There's a bondsman here? There's somebody raising her hand, express bail bonds. State what bond you want. She's lived here 2 years. Looks like she's from Venezuela.
Maybe reduce count 1 to 2,500, standard on the other two,
Now what, do it that low?
or 5,000 then?
Count one will be $5,000. Count two, organized fraud is. 1 minute.
Un momento, por favor. De momento, en la primera
Count two,
instancia,
conspiracy for organized fraud will be $1,000, and count three, false report of a crime to law enforcement is $500. Have a good day.
muy bien, señora. Le queda la acusación número 1, $5,000 de fianza, acusación número 2, $1,000 de fianza y acusación número 3, $500 de fianza. Tenga buen día.
Angela Gutierrez Gago. Also part of the staged accident. Good morning. Spanish or English?
Spanish.
Ma'am, you were arrested for insurance fraud for a staged accident, conspiracy to commit organized scheme to defraud, and false report of a crime to law enforcement.
Buenos días, señora. Usted está acá enfrentando acusaciones de haber hecho un reclamo fraudulento a un seguro a través de la falsificación de un accidente de auto, conspiración para hacer fraude organizado y al haber reportado un delito falso, un incidente falso a la policía.
So I will appoint the public defender's office for you.
Le asigno el abogado de oficio para que le represente.
There is probable cause for the charges.
Tenemos motivo fundado para las acusaciones.
Requesting the same bond as the co-defendant.
How long have you lived in Miami?
¿Hace cuánto que usted vive acá en Miami, señora?
Ahorita en septiembre 2 años.
In September now, it's 2 years.
2 years. She's from Nicaragua. Well, she's not the organizer.
I don't think the other lady was either.
No, it says the other one was, I thought.
Would you
Count
con-
one,
pretrial, Judge? as
nope,
well?
nope. Count one, insurance fraud for the staged accident will be, let's see. Will be, what I said at 5,000? $5,000 for the bond. Count two, conspiracy for organized fraud is $500. Count three, false report of a crime is $500. Have a good day.
Muy bien, entonces, señora, en la primera acusación de haber hecho un reclamo a un seguro fraudulentamente a través de un accidente ficticio, van a ser $5,000 de fianza. En la segunda acusación de haber confabulado para defraudar, estafar, van a ser 500. Y en la tercera, al haber reportado un incidente de delito falso, $500.
And next we have is Sapphire Graves, page 6. Good morning, ma'am. You were arrested for child neglect, disorderly intoxication. I will appoint the public defender's office for you.
She's driving around drunk and got into an accident while she left her 3 kids at home. The children were given to their grandfather by DCF. The A form does say yes to possible mental health disorder.
Okay. I don't have the names of the children, but there'd be probable cause for the charges. What happened to her? Did she get a DUI or no?
NVDL disorderly intox.
Okay.
As a condition of her release, will Your Honor order the defendant to comply with all orders from DCF?
Getting her kids if she don't comply with the DCF orders. Where are the children now? With the grandpa?
Yes.
All right. So, yeah, there's probable cause for 3 counts of child neglect and disorderly intoxication. So are you gonna want me to pass it to get the children's initials or names, or do you want me
I
to
do
say?
have the initials actually, Judge. They're in the narrative.
And the date of birth.
Great. I just don't have the full names.
So you need to prepare a stay away order if you want me to sign one.
Okay. I can do that, Judge. Victims are JI, and then 2 of the children have the initials
So
SI.
stay away from the 2 children, JI, or was it only supervised contact? How do you want it?
Yes, please.
Supervised and
You can only have supervised contact with the 3 children, JI, SI, and SI, and you must comply with any DCF orders, dependency court orders regarding your custody, contact and visitation, and any orders they enter in dependency court regarding your custody, contact and visitation, and time sharing will supersede or replace any of this criminal court order. You understand? So if they say no contact, you can't have any contact with them. But I'm only giving you supervised contact with the 3 children.
Okay.
Miss Seth, do you want to prepare something up, a non-domestic with those names
I can.
or initials and dates of birth, and send it over with your runner, please?
I can't do it right now, but I can bring it over with the afternoon paperwork.
Okay. Is that all right, Erin? Okay, thank you. All right, so what do you want me to give her? Pretrial?
Yes, please.
Pretrial services alternate bond. Count 1 is 2,500, count 2, 2,500, count 3, 2,500, count 4, $150. Have a good day, ma'am.
All right, we're starting to see some more options come up. Let's go to the great state of Tennessee and spend time with Judge Wolf. He is doing his criminal docket this morning.
Unmute.
All right. What is your name, sir?
James Benner. How in the world do I get that screen bigger?
You know what page? Mr. Benner, you're here to be arraigned on a charge of probation violation, a violation of community corrections, actually. You have the right to an attorney to represent you. Would you like to have a lawyer appointed to represent you?
Yes, sir.
Public defender will be appointed.
Your Honor, I acknowledge receiving a copy of the petition and waive formal reading of the same on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. You want to set this for hearing later this month?
Yes, sir, please.
That would be on, looking at October, 29th of September.
Yes, sir.
Your lawyer will be up to talk with you and get you ready for a hearing on our disposition on September the 29th.
All right,
Thank
thank you.
Good
Judge,
morning.
good morning.
What's your name, please?
Warren Esteban Brooks.
Mr. Brooks, you're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
You were my elbow counsel last time, Judge. We went pro se. I was supposed to have an update in September. I've been running the diner down there at Shoney's, and I went to Natchez Trace, and I got on ADD medicine. I have a prescription for sulfameth, SULFAMETH, and I got wary that when I reported to my probation officer, I got wary, Pop. That's all it was. I got wary. But I got clean toxins and I got check stubs. I got a clean record. I just need to be reinstated, Pop. They got me on 8/31, and they got me on 8/30 after the beauty pageant. Me and my daughter, we won the beauty pageant down there, and we won the beauty pageant, and she came in first place, and I was walking home, and I've lost my job at Shoney's. Mr. Dan, he's the man. He's the owner. I've been here for 4 days, Pop. Mr. Wolf, I just need to be reinstated. I can piss in the cup. I just need to go home, Mr. Wolf. I'm running the diner down there. I'm a dishwasher down there in Shoney's. Please, Mr. Wolf. Please.
I'm going to appoint a public defender to represent you so that they can help you with what you're saying is taking place.
Yes, sir.
And I'm going to give them a copy of the charges and enter a plea of not guilty. And then the public defender will talk with you, and if they can establish what you're saying as far as the reason that you may have testified, then we'll go from there.
Thank you so much, Judge Wolf. I just got to talk to Mr. Dan and get my job back. I run that daggum diner down there at Shoney's, Mr. Dan. You come on down there and see us.
Well, I want you to understand the public defender is going to be there to represent you, so let them help you with your defense, and we'll see how we can get this worked out, all right?
Thank you so much, Judge Wolf. I love you, family.
Will that be on September 29, Your Honor?
September 29.
Yes, sir.
Amen. Amen. Thank you, Judge Wolf. Hi, damn it. Oh, thank you, Jesus. September 29.
Well, his daughter won the pageant that he was talking about, so, okay.
I'm about to start crying.
Oh, it's nice to have satisfaction.
Hi.
Good morning. What is your name, please?
Joshua Christian.
Mr. Christian, you're here to be arraigned on a charge of probation violation. You have the right to an attorney to represent you. Would you like to have a lawyer?
No, sir.
You do not want a lawyer?
No.
All right. I want to make sure you understand what you're charged with. It is alleged that you were placed on probation on or about the 14th day of July of this year for driving under the influence of an intoxicant, first offense, reckless endangerment, and felony reckless endangerment by a vehicle. And you were sentenced to a probation for a period of 1 year. It is alleged that you have violated that by violation of Rule 8, because on July 17, 2025, you submitted to a drug screen using a 13-panel urinalysis test, and you tested positive for fentanyl and MDMA. On July 25th, the results were confirmed by Alaire Toxicology Services. So that is what the charge is, and if you are found guilty of that, then you're facing the revocation of your sentence of 1 year, and you would have to serve that in prison. So I ask you again, do you now wish to have a lawyer represent you on this matter?
I imagine I would then.
I don't blame you. A public defender will be appointed.
May I speak? Say one last thing?
I'm sorry?
The drug test was given to me less than 72 hours after I'd pleaded guilty. I don't know if that matters any, but I didn't have any time to clean.
That's the thing you need to explain to your lawyer and let him, Mr. Talbot's here with the public defender's office. He will come and talk with you about it, and we'll let you know what the possible defenses might be to this drug test situation. So I'm going to appoint the public defender and enter a plea of not guilty and set it for September 29th.
Yes, sir.
He'll be up to talk with you and see what that can work out.
All right,
Thank you.
thank you.
Oh, Timothy, I'm sorry. Just have a seat. So just like that.
Good morning. What is your name, please?
Lucy Dawson.
Mr. Dawson, you're here to be on an indictment charging you with possession of methamphetamine with intent to deliver over 0.5 grams, simple possession of a Schedule 1 drug, simple possession of a Schedule 2 drug, simple possession of a Schedule 6 drug, and unlawful drug paraphernalia. You have the right to an attorney. Do you wish to have a lawyer represent you?
I've already been to court I've already had an attorney appointed. Also,
All right, was it the
I've had a
public?
preliminary hearing. I've already had a preliminary hearing and everything on all this.
Oh, sir, I represented Mr. Dawson in the
All right.
preliminary hearing in general
The
session.
lawyer that you previously had is here, and I'm appointing him to represent you with, he's with the Public Defender's Office. So
Yes, sir.
we'll
Thank
appoint-
you.
And, Your Honor, I acknowledge receiving a copy of the indictment. I waive formal reading of the same. On behalf of Mr. Dawson, I enter a plea of not guilty.
plea of not guilty is entered. Do we want to set this for a status day, or how do you want to handle it, gentlemen? January 7th? All right, January 7th for status. What that means that your lawyer's going to come talk with you, get you up to date on what the status is and what the evidence is against you, and we'll see you on January the 7th. If you're able to resolve it, then we'll let you dispose of the case by an agreement. If not, then we'll set you a trial date. All right?
Okay, Your Honor, I got one question. I've got a court date for September the 29th.
That's a
And
violation of probation, and I don't have that one on my docket, but that will likely be continued until after this January 7th date.
okay, that's what I couldn't understand. I thought they had them all the same day.
Right.
Okay. All right, thank you, sir. Thank you. Is that all?
You're fine. Yeah, we're done with you. They'll be up to talk with you. Thank you.
Thank you, sir.
Good morning. What is your name, please?
Chaz Green.
Page 6. Green, you're here to be arraigned on a charge of aggravated domestic assault in one indictment. Another indictment is charging you with possession of a weapon by a convicted felon and knowingly violating a condition of release, as well as a violation of conditional release. You have a multi-count indictment, and as a result of that, you have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender?
Yeah, I should have Odom.
Did you have a lawyer in the lower court appointed for you?
Yes, sir. I had Mr. Odom.
Mark Odell?
Yes, sir.
All right. Well, we're going to go ahead and appoint Mr. Odell to represent you as well. And let's stand in for Mr. Odell, if you will, Mr. Talbot.
Standing in for Mr. Odell, I acknowledge receipt of a copy of the indictment and waive formal reading of the same on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. This is General Sylvie's case. Do we know if she wants to set a trial date? And General Sylvie, you're here. Just didn't see you in the back there. They're looking for those dates, I think. Is that a trial date or a status date? So the December 1st is a status day? And
We
that's,
could set it for a status with that as well.
all right. Mr. Green, we're going to put these new cases with some that are already pending on December the 1st, so that these will also be set for that day to let your lawyer work on these cases as well as the other cases. So a plea of not guilty is entered, and Mr. Odom will be given a copy of these charges, and he'll be up to talk with you as quickly as he can.
Okay, yes, sir. And then is there any way about the bond source hearing or anything?
Mr. Odom will have to file a motion for a bond, and then we can deal with it at an appropriate time.
Okay, yes, sir.
All right. Thank you.
Thank you.
Good morning. What is your name?
LaMarcus Jackson.
All right, Mr. Jackson. Jackson is on page 7. Public defender represents Mr. Jackson.
Yes, sir. And we'd already been appointed for a VOP on 10/20. I understand this is an amendment he needs to be arraigned on.
This is an arraignment on an amended violation of probation, and the original one is set for October the 20th, so we'll leave this one.
Could we move it up to this month, Your Honor? I think we can probably get it resolved.
That's fine. We'll show the public defender is appointed to represent the defendant on this new amended charge, and we'll set it for hearing on September the 29th.
Thank you, sir.
All right.
Thank you.
Good morning. What is your name, please?
Garrett Jones.
All right, Mr. Jones, you're here to be arraigned on an indictment charging you with possession of methamphetamine and of 20.26 grams or more, and also possession of manufacturing or delivery or sale or conspiracy to do that of certain drugs, and money laundering. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender?
Yes, sir.
Thank you, Madam Clerk. Your Honor, I acknowledge receipt of a copy of the indictment, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Now, there are three co-defendants, is that correct? Any idea of whether or not that presents an issue for you?
No, sir, no issue.
All right, we'll leave you in the case until then. All right, General Stevenson, you wish to let me know how you want to handle the scheduling of this? January 7th. All right, January 7th for status. Public defender's been appointed you to represent you, Mr. Jones, and they'll be up to talk with you and get you ready for either a disposition on your case in January, or we'll assign a trial date. Thank you.
Thank you, Your Honor.
Good morning. What is your name, please?
Ronnie McCoy. Judge,
Sir?
I've been here almost 3 years and I've never seen the evidence the state has against me or anything else. I don't know. Matthew Bruner was my attorney and he withdrew, and now I've had, since February, I've had three different attorneys that's had conflict or whatever. But I still have yet to see what the state has against me.
All right, Mr. McCoy, the problem that we have is that you're one of a number of defendants that were all on a conspiracy count, and I think there were like 27 defendants that were charged in one indictment. That presents ethical problems for lawyers to represent more than one of these individuals. And I understand that you've been awaiting trial for a long period of time. And the problem is that we keep appointing attorneys who, for whatever reason, have to withdraw. For example, the attorney that we appointed the last go round, an attorney named Vid Sanker, has now surrendered his law license. He is no longer practicing. And as a result of that, I've got to find another attorney for you. Let's bring Mr. McCoy over at 1 o'clock for me to, and I'm going to find you a lawyer, and we're going to deal with your situation as quickly as we can to try to get something done one way or the other in your case. So we'll bring you over here at 1 o'clock, and I'll see what I can find out between now and then, okay?
Okay. Thank you. No, I can't see none of y'all.
Real quick, you got to say this about Tennessee. I'm hearing a lot more pleases and thank yous. So that's kind of nice. Anyways, back to Judge.
Page 13 and 14. All right, Mr. Robinson, you're here to be arraigned on an indictment charging you with violation of the sex offender registry form in violation of community supervision. In one indictment, you're also charged with resisting a stop, arrest, and search and evading arrest in a separate indictment. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
All right, then I'll appoint the public defender to represent you.
Yes, sir. I acknowledge receipt of a copy of the indictments and waive formal reading of the same. On behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. General Bryson. All right, be set for status on January the 7th. We're setting it for January the 7th of 2026 for you to dispose of your case by an agreement, or we'll assign a trial date on that day if you've not been able to arrive at an agreement. If you get something worked out with your lawyer, then it can be taken up earlier than that on a different court date. But right now, that's where we're setting it.
And who, what's my attorney's name, sir?
Go ahead.
My name is Zachary Talbot. I'm with the Public Defender's Office.
Okay.
Good. Thank you. Morning. What is your name, please?
Walter Whitmore.
On page 18. Mr. Whitmore, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
No, sir.
No?
No.
All right. Let me arraign you on this charge. You are charged with having been placed on probation on or about the 25th day of February 2014 for the offense of promotion of manufacturing of methamphetamine, and that you were sentenced to 2 years, and that you had allegedly violated your probation by violation of Rule 5 in that on or about January the 15th of 2015, you had been kicked out of your last reported residence and had not contacted your probation officer to update your address. And for that reason, there was a violation of probation warrant that was issued. It's also alleged that you last reported to probation December the 22nd, 2014, and failed to report for the month of January 2015. And you also have not paid your supervisory fees or your court costs. Now, I'm not sure of exactly what the circumstances were in this case, but because of the fact that this is a case that's pending since 2015, I'm going to appoint the public defender to represent you because there's an issue that's come up with some appellate court decisions that I think you're you need to make sure that you get the benefit of legal expertise to raise any issues that might exist.
All right.
Public defender will be appointed. We'll set it for September the 29th. Plea of not guilty is entered.
Yes, sir.
I understand you. I know you're well aware of the issue that I'm concerned about. So.
Yeah.
All right, September 29th.
Thank you.
Ashley, 10 gifted memberships. Thank you so much. You're always so kind to not only me, but everybody here at this channel, and it's very much appreciated. So thanks a lot. I appreciate it.
Good morning. What is your name, please?
Ladera Williams.
Mr. Williams, you're here to be arraigned on an indictment charging you with theft of property, simple possession of methamphetamine, and possession of drug paraphernalia. You have the right to an attorney. Do you wish to have a lawyer?
Present today or just in general?
I'm sorry, you want to have a lawyer appointed for you?
For now, yes, sir.
All right. Public defender will be appointed. Sorry.
Your Honor, I acknowledge receiving a copy of the indictment, waive formal reading of the same, and not guilty on behalf of the defendant.
All right. Status day, January 7th, General. Except for status on January the 7th of 2026. What that means is that we're going to give your lawyer time to work on a resolution of your case. If it's able to be resolved by an agreement, then we'll take it up either before or on January the 7th. And on January the 7th, if it's not resolved, we will assign a trial date. Thank you.
Is that it?
Yep, they'll be up to talk with you and try to get you ready for disposition or trial.
Thank you, sir.
All right, thank you.
Michael and Barbara, thanks to both of you for each gifting a membership. Appreciate that. By the way, speaking of Michael, if you're not already subscribed to his channel, go over there. He is on a great run at the moment, really growing, and I want to continue to make sure we support him. So if you're not already subscribed to Michael, do that. Barbara just dropped a link to his channel in the chat. Let's change it up a little bit. Let's go to Michigan. Judge Elmore, he's got somebody that's about to sit down at the defense table. Let's see what that's all about.
All right, we are back on the record now for the 28th Circuit Court, and this time we're taking up two cases. Each of these two cases are entitled People of the State of Michigan versus Jennifer Lee Williams. The case numbers are 25-14094FH and 25-14117FH. Appearances?
Joanna Carey for the people.
And I'm Jeff Harrison. I'm here at behalf of Ms. Williams. She's seated to my left.
All right, thank you. We're here today originally scheduled for just a pretrial conference on file 14117. However, during that pretrial conference in chambers, the parties informed me that they had a resolution reached and addressed another case that is currently set for a final pretrial conference in a couple weeks. And it's going to be, the plea today is going to resolve both of these files. Ms. Chair?
It's my understanding that in file 25-14094, the defendant is going to plead guilty to count 1, possession of methamphetamine. The people dismiss count 2, individual offender second notice. File 25-14117, it is my understanding that the defendant will plead to disorderly person, count 3, and an added count 4 of attempt, resist, and obstruct a police officer. The remaining counts in the habitual offender second notice will be dismissed.
Mr. Harrison?
That directly comports with my understanding, Your Honor. Thank you.
All right, thank you. Ms. Williams, is that how you wish to resolve these two cases today?
Yes, sir.
To the best that you can, please raise your right hand. Ma'am, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth? You may lower your hand. All right, Ms. Williams, the older file here had an alleged offense date of June 23rd of 2025. And that time, were you on probation, parole, or bond for any cases? Were you on bond or were you being supervised by a probation officer?
No, sir.
All right. Now, looking at the next date on August 8th of 2025, were you on probation or parole, being supervised? Or were you on bond? Let's take a look here.
Oh, you're on bond from the June case.
So, looks like the alleged offense date for the first file was June 23rd, and then the charges were filed and you were arrested on the 24th. Now, the other file, which has an alleged date of August 8th, would suggest that you might have been on bond.
She was.
All right, thank you. So, because you were on bond, for a felony charge, you could be sentenced consecutively for these two offenses. That would be within the discretion of the court. I don't know if I would do that. I would go concurrent, but I need you to know that it could be a possibility. Do you understand? All right. Now, in these files today, you've sworn to tell the truth. Make sure everything you tell me is the truth, because that's how I will forever treat it. All right. In the first file, ending in 9-4, you are currently charged with possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. There is a second habitual felony offender enhancement included, which could increase that maximum punishment from up to 10 to up to 15 years, and from up to $15,000 to up to $22,500. However, if you plead guilty to count one, and I accept that plea, that enhancement will be dismissed and you'll just face the felony punishable by up to 10 years. There is a count 2, which is possession of contraband inside of a jail. That is a felony punishable by up to 5 years and or up to $1,000. And if you were sentenced as a second habitual offender within the discretion of the court, that could be increased from up to 5 to up to 7.5 years, and from up to $1,000 to up to $1,500. However, count 2 will be dismissed as well. So far, that older file, is that what you understood to be the terms of your agreement?
Yes, sir.
In the other file, you are charged with a count of possession of methamphetamine, which again is a felony punishable by up to 10 years and up to $15,000, which there is a similar second habitual felony enhancement that could have increased that from up to 10 to up to 15 years. However, count 1 will be dismissed. Count 2 is a charge of assault, resist, obstruct a police officer. That's a felony punishable by up to 2 years and or up to $2,000. Plus is a second habitual felony offender that could have been increased up to 3 years and up to $3,000. However, count 2 will be dismissed if you enter a plea to an added count 4 of attempt to assault, resist, obstruct a police officer, which would be a misdemeanor punishable by up to 2 years and or, a misdemeanor punishable by up to 1 year and up to $1,000. Count 3 is a charge of disorderly person, which is a misdemeanor punishable by up to 90 days and or up to $500. And there is no felony enhancement to the sentence because it's not a felony. Is that what you understood you were doing today?
Okay.
Now, by entering a plea of guilty, if I accept that plea, you will not have a trial. Does that make sense? You'll also be given up certain rights that you would have at a trial. That, of course, includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented. The right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. Ms. Williams, do you understand that by pleading guilty, you'll be forever waiving those rights as they apply to these two cases? Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not an automatic claim of appeal by right, which is only allowed when you're convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. And you will also be given up the right to claim the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to force or compel you to plead guilty that we have not yet discussed?
No, sir.
And are you entering the pleas today of your own free choice?
Yes.
Now, Mr. Harrison has probably talked to you about the Michigan sentencing guidelines. Try to give you an idea as to what he thinks this court might sentence you to. I want to let you know that the guidelines are not mandatory. The court is, however, required to take a look at those and consider them in reaching their sentence. And any estimate that Mr. Harrison has given you is just an estimate. So if you understand, has anybody made a promise you as to exactly what the sentence would be?
No, sir.
Knowing all that, do you still wish them to the pleas of guilty that we discussed earlier?
Yes.
In file ending in 9-4, as to count 1, possession of methamphetamine, how do you plead?
Guilty.
And before the court can accept that plea in that case, I need you to tell me what you did that makes you guilty of offense. Turning your attention back to June 23rd of this year, 2025, within the city limits of Cadillac here in Wexford County. What happened? How did you have an encounter with police?
Well,
May I assist you?
Sure, you know more about it than I do.
Irrespective of why, you found yourself being admitted into the jail that evening, is that correct?
Yeah.
And in the course of them searching you prior to your entry into the jail, it's determined that there was a baggie in one of your pants pockets?
it was, after I, actually in the jail for,
Okay.
for at least a few hours, maybe even.
Okay, but you were still an intake.
Yes, I was in
Okay.
it, yeah.
So a further search of your person revealed this baggie on your person.
Yeah, and they were changing me out, yeah.
Okay. Oh, okay, right, that makes sense. And that, tell me about that baggie. What had been in that baggie?
Methamphetamine.
Okay, was there still some dust or residue on that baggie that you could,
Yeah,
made it pretty obvious what it was?
there was, yeah, there was.
Okay, and you knew it was methamphetamine?
Yeah.
Okay, how did you know it was methamphetamine? Did you use some of it?
Yeah.
Okay, and then you don't have any lawful right to use or possess methamphetamine?
No, sir.
Wasn't prescribed or anything?
No.
Okay, thank you. I believe that covers it, Your Honor.
All right, thank you. Turning to file ending in 1-7. Ms. Williams, as to count 3, disorderly person, how do you plead?
Guilty.
As to added count 4, attempt to assault, resist, obstruct a police officer is a misdemeanor, how do you plead?
Guilty.
Now, before the court can accept that plea, I need you to tell me what happened. Turning your attention to August 8th of 2025, again within the city limits of Cadillac in Wexford County. What happened on that day?
At G&D parking lot, and I was approached by 2 men who were bounty hunters, and my arrest, and they called police to arrest me. Chaotic. I was a
So
little bit
did
heated.
police come to the scene?
Yes.
And did you recognize them to be police officers based upon either their uniform and or their
Yes.
patrol car?
Yeah,
And did they attempt to take you into custody?
they did.
And what happened when they attempted to do that?
I think I was was already kind of wrestling with the bounty hunter, and it continued for a few moments.
With the law enforcement officers?
Yes, sir.
Okay, what did you do to resist them?
I was just trying to shake my arms away from them handcuffing me.
Okay. Now, Mr. Harrison, I don't really know what this disorderly person jostling foundation is. Maybe you could help me, please?
I think I can help you with that, Your Honor.
Thank you.
That night at G&D,
Okay.
by the way, for the record, that's a party store located here in the city of Cadillac, right there on Mitchell Street. Okay. You were approached by these two men and they indicated their intention was to apprehend you. Is it fair to say that that was not what you wanted to happen?
No, yeah, it's fair to say that.
Okay.
Because I thought I was gonna be having a visit with my son. And
Okay.
so it was really unsettling because I was gonna turn myself in. I knew I had warrants, and I had the chance to meet and see my son, who I haven't seen in a long time. And
Okay.
the fact that it was bounty hunters instead of.
Yeah. Okay.
really-
Did you raise your voice in opposition to
Yeah.
what they were trying to do? Did you
Yeah,
do
it's
what
really-
would be called causing a scene?
Yeah, yeah.
And you also mentioned previously that you were quote wrestling around with those guys.
Yeah.
Did they attempt to physically restrain you and you resisted that as well?
I tried to, yeah.
Okay. I think that's sufficient, Your Honor.
Ms. Carey, in both files, do you believe the defendant provided a factual basis for the police in those files?
I do.
Are you aware of any other promises, threats, or inducements?
I'm not.
Do you believe the court thus far is in compliance with Michigan Law 6.302?
Yes, sir.
Mr. Harrison, what say ye?
I agree with all three of those propositions.
The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for those offenses, and therefore, in file ending in 9-4, she is found guilty of count 1. The remaining charges and enhancements will be dismissed at the time of sentencing. And in the file ending in 1-7, she is found guilty of count 3 and added count 4. The remaining counts and any other enhancements will be dismissed at the time of sentencing. Ms. Williams, the case will now be set for sentencing. I can predict that will be in about 4 weeks from this coming Monday. Them on Monday morning. Between now and then, an agent from the Michigan Department of Corrections is going to need to prepare a pre-sentence investigation report. That report will discuss the events, describe the pretrial agreement, provide me information about you, medical history, mental health history, work history, and education history. And it will also include a score in the guidelines, which I mentioned earlier are not mandatory. And it will make a recommendation as of the sentence, which is also not mandatory, as the court alone is who makes the sentence. There are 3 steps that involve you. 1, you're going to get a packet, which has just been handed by the clerk to the corrections officer. And you're going to open it up, fill it out, turn it in. Then you'll be subject to an interview with one of those agents. You have the right to have Mr. Harrison present during that interview. And third, Mr. Harrison, when he gets this report, which is generally in about 10 days to 2 weeks before sentencing, he'll have to come and meet with you to go over the contents. Each side has the right to come back to the court, request corrections, or make objections to the contents of it. We want to make sure that it is complete and accurate before the court uses it to issue a sentence. Do you understand, Ms. Williams?
Yes, sir.
Do you have any questions, Ms. Williams, about what we have done today?
No.
Thank you. Anything further today, Ms. Carey
For the people.
and Mr. Harrison?
Nothing further, Your Honor. Thank you.
Ms. Williams, we'll see you in about 4 weeks. Thank
Okay,
you.
thanks very much.
Yes, ma'am.
All right, folks, because I need to catch up and I didn't want to interrupt the hearing, thank you to Lindsay, 20 gifted memberships. Thank you to Bailey for gifting a membership. And thank you to Barbara for gifting 5. You guys are very generous once again. This seems to be a Friday thing, and I surely do appreciate it. Before we go to the next court, let's take a moment and talk about the sponsor for today's show, and that is Aura. You've heard me talk about Aura, and I talk about them for good reason. First off, they came to this channel and said, we want to partner with you, and that's kind of a huge thing because Aura is a big, powerful company that does good things, though. they're a one-stop shop when it comes to protecting yourself and protecting your data online. It makes sense to have them partner with a court channel. But I made them prove what they could do before I would agree. And I'm looking through my dashboard live right now with Aura. And it's amazing to me the companies that they're removing my data from. And they do this every day. And sometimes the data comes back to these companies and they remove it again. And they're doing great work for me because I don't have the time for it. But what's scary to me is not only these companies have my data, but I don't know who they are. Names that just don't make sense. Who in the world is Alesco Data or Brooksim or Fetcher or IQVIA or Merkle or Pop Acta or BDO or Reclaim spelled with a K or Black Bod or Samba or Saiba or Viva. I have no idea who these people are, but Aura does, and they're working to protect me online every single day. But it's not just them removing data from data broker sites like that. They also have identity protection, so if your identity pops up in a bad place, obviously they work with that. They monitor your transactions for anything that looks bad. Antivirus, VPN, parental controls, spam call protection, which is a huge thing I've been benefiting from. You name it, they can do it. And the good news is, because they partner with this channel, you get 2 weeks for free. So try them out. It doesn't cost you a dime to do it. Aura.com/TCF. Go there, sign up. It's fairly quick and fairly easy, and you'll get 2 weeks to figure out what they can do for you and if they'll be right for you. Honestly, you'll find out within the first 24 hours exactly what they can do for you, and if you give them a couple of days after that, you'll start to see your information disappear from these online brokers, and it just works. So if you're on the fence about it, get off the fence. I've been talking about it long enough, folks. Just sign up. Trust me. Aura.com/TCF. And look, I'm a customer of theirs now. I believe in it that much, so give it a look. Let's go to Florida. Wade Mercer, first appearances.
Ms. Horn, your sister's in the courtroom, ma'am. Ms. Horn, you're here because you have been accused of, it's a failure to appear on a pretrial case. It's a 2016 case, 2016-658, and the charge is failure to redeliver a hired or leased property. The allegation is you missed a pretrial conference in February of 2019, I believe, and have been gone since. So you've got no bond, Ms. Horn. You're going to be held with no bond until you can get over to circuit court and try to get this case resolved. Mr. McDaniel, I asked Ms. Williams what the next pretrial date was, and we think it's October 21st. Does that sound right to you, Mr. McDaniel?
I'm not sure. I thought pre-trials, yes, that'd be correct, Your Honor. Your Honor, there's also that other case, 1890, that she's got. And just to, I'm not gonna say let her out today. Just recall that this is the month before the hurricane, the 2 months before the hurricane. And she paid a $500 cash bond, I believe, to get out of jail. They mailed her a notice. That notice come back undeliverable because she had been relocated after the hurricane. And she's in North Carolina, was working there. She works at Food Line in North Carolina. So just, take that. I don't know what else to ask. I know it's been several years, but so.
Okay. Thank you, Mr. Mitchell. Anything?
No, Your Honor.
So, Ms. Horn, I'm going to keep you right where you're at. You've disappeared on us for 6 years. I think it'd be foolish of me to think that I've let you out. You're going to come back to court voluntarily. It appears there's certainly evidence that you have avoided this case for several years. So you're going to be held with no bond until your next court date. Ms. Horn, do you have any questions?
No, sir.
Ma'am, in the courtroom, do you have any questions?
Then you said that she'll be held until
Her court date is October 21st, and I have no idea what will happen that day, but that'll be the next time she's in court. She may get it resolved. She may get out that day. I don't know, but that'll be her next court date. And you can contact the public defender's office if you want and find out who her attorney is, and they'll give you that attorney's name and phone number. If she's Well, I can probably
Wade
tell you.
It's Wade.
Wade
Mr. Owens. Mr. Owens with the Public Defender's Office is who you would talk to. Okay.
And don't, that other case number, we put that docket also.
I couldn't hear you, ma'am. Say it again. She's been gone for 6 years.
Oh, I'm sorry.
She's not going to get a bond because there's a great possibility she won't come back. She's avoided this case for 6 years. She's not going anywhere until she sees Judge Garcia. You have any other questions? All right. Have a good day, ma'am. Wish you the best, Ms. Horn. Jessica Tice is next. Ms. Tice, good morning. You're here because you've been accused of violating the terms of your probation, ma'am, at 24-186 and 24-176 CF. Those are both felony cases. I've got a copy of the warrant in front of me, Ms. Tice, and it's a no bond warrant. So you're going to be held with no bond until you can see Judge Garcia. I want to go ahead and get you arraigned. If you want a lawyer appointed, we're going to try to do that today. Would you like to have an attorney appointed to represent you in the VOP, ma'am?
Yes, sir. Is there any way I could get Wade Owens or, oh, never mind.
I'm going to appoint the Public Defender's Office. Let's get them appointed, then we'll see if you have any questions in just a moment. Mr. McDaniel is going to give you a court date, and we'll see if you have any questions. Mr. McDaniel?
Your Honor, we're going to plead not guilty. Ask us to set this on the next pretrial date, which is October 9th. I've already advised Mr. Guy Green to come out and talk with her and she can address any issues she has at that point in time.
All right, thank you. Mr. Mitchell, anything from the state?
No, Your Honor.
So October 9th will be your court date. Mr. Guy Green is the attorney that does VOPs. Mr. Owens does new felonies. The only time he handles the VOP is if there's a new charge and a VOP. So chances of you having him is unlikely, but that's a decision to be made by the Public Defender's Office or Public Defender, Mr. Sims. Do you have any questions, ma'am?
No, sir.
All right, ma'am. Have a good day.
You too.
Thank you. David Robinson, Jr. Mr. Robinson, good morning. Mr. Robinson, you're here because you've been accused of one count of trespass, one count of resisting an officer without violence, and one count of violation of probation. Mr. Robinson, I read the complaint. I actually had to read it a couple times, but I felt like there's enough for probable cause there. And I'm going to see what additional information the attorneys have. Before I hear from you, Mr. McDaniel, I just got a text from the sergeant. I requested your analysis because of Mr. Robinson being on probation and because of the allegations in the complaint. The officer felt like he may be on some kind of substance. And what I've been told so far, Sergeant, he's not been able to give a urinalysis sample yet. Is that correct?
Yes, sir.
Okay, Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
No, nothing at this time, Your Honor.
Is the state asking for a 7-day hold based upon the new charge if he takes and submits a clean urinalysis? Mr., are you still asking for the normal 7-day hold? What's your thoughts?
Well, I think when we were looking it up for violation of probation, it just says it's an interstate compact, so I don't exactly know where to contact.
Well, you would contact the probation office.
Yeah.
And it's their responsibility, but the chances of you hearing anything within 7 days is not real high.
Yeah, and
Based on my
so,
experience.
and that's what I was thinking right there, based on all those factors. I'm not requesting it. We can leave it up to the court to determine if that's appropriate, but that's my take on it.
So, Mr. McDaniel?
My opinion, I don't think he's gonna be able to bond out, Your Honor, so I don't think it's gonna matter. Would that help you make a decision on taking a drug test, or you're not gonna take the drug test?
I was trying to, but I just got out the shower, so I couldn't use the bathroom.
All right, so what I'm gonna do is this. I'm gonna set a bond on the new trespassing case of $5,000, on the new resisting officer case with $5,000. So your total bond is $10,000 cash or surety. I want to ask that he be held until Wednesday. And on Wednesday, when I get back at first appearance, I'm asking to notify probation. If they say they're going to have some answers within 7 days, I need to know that.
Okay.
That would be unusual on an out-of-state case. Mr. Robinson, they're going to give you a chance to give your analysis between now and lunchtime today. So you've got several hours. You can still give a urinalysis sample. The officer's complaint says that he or she believes that you may be on some kind of illegal substance, is what the complaint says. So we'll see what's in your system and we'll go from there. If you take the urinalysis and you pass it, I'm certainly willing to possibly lower that bond on Wednesday. If you take the urinalysis and you don't pass it, then that's going to be an additional violation of probation, and I may even hold you longer than the 4 or 5 days I've said originally. Mr. Mitchell?
If you do lower the bond and he does bond out, we also request he have no contact with any Dollar General.
Thank you. There is a condition on the bond, no contact with any Dollar General until this case is resolved. So I'll see you on Wednesday, Mr. Robinson. Any questions?
No, sir.
All right, sir. Have a good day. Bonnie Paget. Ms. Paget, good morning. Ms. Paget, you're here for a holdout of Union County. I've got a copy of the paperwork from that Sheriff's Department. It says it's a violation of probation warrant, ma'am, and it has no bond on it. So, Ms. Paget, you'll be held until you can get to Union County. Today's Friday, ma'am. I'd be surprised if they pick you up today because it's not a neighboring county. More than likely, you're going to get down there in the next 7 to 10 days. When you get there, Ms. Paget, you'll go to another first appearance in front of a local judge, and that local judge will address your bond. But what we have been provided from them right now says no bond. Do you have any questions?
No, sir.
Have a good day, ma'am.
You too.
Thank you.
Thank you.
Mr. McDaniel, I have a motion for continuance on State versus Cheyenne, Lori Mills Wright, 25-340 MM. And I want to make sure y'all are on the same page on this. The motion says no objection, and my plan is to set it for next pretrial and case management unless there's something else I need to do. Mr. McDaniel?
Yeah, I don't have anything else. Does she still need to be here for this next pretrial, I guess, or,
Mr. Mitchell?
I mean, if she does want to go ahead and resolve it, we could just bring her up at any time after first appearance, so we can go ahead and set her.
I didn't mean to interrupt you. She's not in custody now, right?
No, she's bonded out, so we can go ahead and reschedule her for the next pretrial and trial date.
You okay with that, Mr. McDaniel?
I am, and I'll try to give her a call or a note.
So, Dawn, if you will do on this motion to continue, I think there's an order in my e-portal, so I'll grant the order continuing it and we'll reset it for the next trial date and the next pretrial date. So you can take her off of this coming up pretrial, and I'm gonna ask Mr. McDaniel to notify her that she doesn't have to be here for that date, and we'll put her on the October pretrial and trial date, out of custody date.
I think that's the 15th.
That's all I had on my list this morning. Anything else, Mr. McDaniel, from the Public Defender's Office?
Got enough, Your Honor.
Thank you.
All right, since they're wrapping up there, let's go back to Tennessee, spend a little more time with Judge Wolf. At least, yeah, okay, there we go.
I need you to unmute the jail video, please. There you go. Good morning. What is your name?
Christine.
King, you're here to be arraigned on an indictment charging you with aggravated burglary of a habitation, theft of property, falsely representing yourself as a lawyer. That's interesting. And financial exploitation of an elderly or vulnerable person and criminal impersonation. You represented, well, I don't want to ask you any questions, but the indictment on count 3 states that the grand jurors aforesaid upon their oaths aforesaid do further present and say that on or about July 30th, 2025, and prior to the filing of this indictment in the county and state aforesaid that said Christopher Lane King and Amanda M. Roberts then and there did unlawfully, feloniously, directly or indirectly, falsely represent themselves as a lawyer, to wit, Roger Wainick, in violation of TCA 23-3-108, Class C felony, all of which is against the peace and dignity. That's the first time I've ever seen, and I'm not even going to say how many years I've been in the legal profession, but I've never seen that charge. In any event, you have the right to an attorney, an actual attorney, Mr. King. Would you like to have an actual attorney represent you?
Yes, sir.
Do we want to appoint Mr. Wainick to represent him? Are you wanting to be appointed? All right. Does the public defender have any reason that you couldn't represent this defendant? You would have a conflict. This is the, what's wrong with my hand scribble list? Mr. Atchison, you're first on the list. Do you know of a reason you couldn't represent this defendant? All right. Mr. King, I'm going to appoint Mark Atchison, who's an accomplished and skilled litigator in his own right, and we will appoint him to represent you.
Judge, I'd acknowledge receipt of the indictment, waive formal reading, and enter a plea of not guilty at this time.
Plea of not guilty is entered. We want to set this for status on January the 7th. All right, we've set it for status on January the 7th of 2026, and your lawyer will be up to talk with you and see if he can get you ready either for a resolution by an agreement or we'll set you a trial date on January the 7th, 2026. Thank you.
Thank you, Judge.
Good morning. What is your name, please?
Eckford Jefferson.
Mr. Eckford, you are here today to be arraigned on a charge of violation of probation. You have the right to an attorney to represent you. Do you want a lawyer?
Yes, sir.
Public Defender's Office will be appointed.
Acknowledge receiving a copy of the petition, waive formal reading of the same, and enter on behalf of the defendant a plea of not guilty.
Plea of not guilty is entered, set for hearing on September 29th.
Sir.
Lawyer will be up to talk with you and get you ready for a hearing on September the 29th. Thank you.
Thank you. You have a good day.
You go at the very end of the line, all of you come next.
Good morning. What is your name?
Kenneth Oz, Mr. Wolf.
Mr. Ogg, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
I can't afford one.
Okay. Do you have some other charges? Are those still pending, and do you have a lawyer on those charges?
Only charges I know I have was in general sessions, but it was all taken care of.
Well, I'm going to appoint the public defender to represent you since you're in jail.
Yes, sir.
Yes, Your Honor. I acknowledge receiving a copy of the petition of the warrant and waive formal reading of the same and enter on behalf of the defendant a plea of not guilty.
Plea of not guilty is entered. Do you want to set this for the September 29th day?
Please, Your Honor.
All right, September 29th. Public defender will be up to talk with you and get you ready for a hearing on that day.
Thank you, Your Honor.
Thank you. Morning. What is your name, please?
Raymond Perez.
Page 13. Mr. Perez, you're here today to be arraigned on a charge of possession of Schedule 6 drugs, possession of a firearm with intent to go armed during a dangerous felony, possession of unlawful drug paraphernalia, violation of a no contact order, and possession of a firearm, and possession of a controlled substance. You have the right to an attorney. Do you wish to have a lawyer?
If I can get one appointed to me.
Yes. Public Defender's Office is here. They'll be appointed to represent you.
Yes, Judge. I acknowledge receipt of a copy of the indictment, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. General Bryson, you want that January 7th date? We're going to set you for status on January the 7th. If your case can be resolved either before then or by then, if not, we will give you a trial date on January the 7th. Your lawyer will be up to try to talk with you and get you ready for a disposition or for a trial. Thank you.
Yes, sir. Is there a way I can get a bond reduction?
Well, I'm going to let your lawyer talk to you. This is the beginning of our month in September, so your lawyer can talk with you about the bond issue, and if there needs to be a bond reduction or a bond motion, then they can file it for you, and then we'll set you for a hearing, okay?
Yes, sir.
All right, so they'll be up to talk with you about all those things.
Yes, sir.
All right, thank you.
All right, Barbara asks in the chat, what is a Schedule 6 drug? So I just looked it up. In Tennessee, marijuana is the only substance classified as Schedule 6. Conviction for possession of a Schedule 6 substance can lead to significant penalties depending on the amount possessed. There's simple possession, which is a misdemeanor, possession with intent to distribute, which is a felony, and cultivation, which is a felony. So specifically, they're talking about marijuana.
Violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public Defender's Office is here, and they will be appointed to represent you.
Your Honor, I acknowledge receiving a copy of the warrant, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. We'll set you for hearing on September the 29th. Public Defender's Office has several attorneys. One of them will be up to talk with you about your case and get you ready for a hearing on September the 29th, okay?
Sir.
Thank you.
Thank you.
We'll come back to Judge Wolf probably, but let's go to Miami-Dade. We're getting towards lunchtime. Let's see how she's holding up.
Covered over 1.1 pounds. It's, I believe, and he's facing a 15-year minimum mandatory sentence. I'm setting the bond at $100,000.
Bueno, tenemos motivos fundados para la acusación 1 y 4, la acusación 1 siendo el tráfico de cocaína y teniendo en cuenta la amplia cantidad recuperada que excedía una libra, era más de 1.1 libra, y además los 15 años mínimos obligatorios de sentencia en caso de que fuese hallado culpable. Yo voy a imponer los $100,000 de fianza requeridos.
Counts 2 and 3, release outright, no probable cause.
En las acusaciones 2 y 3, sin embargo, quedará liberado directamente porque no hay motivo fundado.
Count 4, there's probable cause for sale of cocaine. You want me to make it $1,000 in that one?
Right.
$1,000, count 4, and counts 5 and 6, release outright.
Entonces, en la acusación número 4, en la venta de cocaína se le ponen $1,000 de fianza y las 5 y las 6 va a ser liberación directa.
Plus a nebia requirement. You have to show the money used to post your bond is from a legitimate source of funds.
Además, señor, usted va a tener requerimiento nevia, lo que significa que va a tener que demostrar que los fondos que utilizará para pagar su fianza provienen de una fuente de ingresos legítima.
Good day, sir. Next we have is Glenn Rose.
Buen día.
He's a violent felony offender of special concern.
Good morning, Mr. Rose. You were arrested for possession of cocaine. I will appoint the public defender's office for you. There's probable cause for the charges. He had like 1.5 grams of cocaine, it looks like. And another bag, maybe 2 grams of cocaine. What bond do you want?
Standard.
Huh? All right. It's
Hard to believe
2,500.
he asked.
Would you consider pretrial, Judge?
No, he's a violent, what do they say, a violent felony offender of special concern, $2,500 bond. Next is Watson Pierre,
He needs Creole interpreter, Your Honor.
Creole interpreter.
The Creole interpreter is present, Your Honor.
Miss
She needs
She's
to be promoted.
present. Thank you. Hi, Miss Wilson. We got to promote her. Good morning, sir. 1 second, please. Miss Wilson, I need you to unmute and put on the video. Are you there?
Good morning, Your Honor.
Good
Yes, I
morning.
am.
Raise your right hand. Have you been sworn today?
Yes,
As an
I have.
interpreter? They're
I
still
have
under oath. Good morning, Mr. Pierre. You were arrested for grand theft with others, a second-degree felony.
Bonjour, Monsieur Pierre. Yo accusé au côté arrêt ou t'essayé voler un bagage et son crime deuxième degré.
So this is from May 16th of 2025.
Mais ça, son bail qui t'est passé le 16 mai 2025.
I need a moment to review the arrest affidavit for probable cause.
Bon, moi, petit moment pour moi voir affidavit d'arrestation pour moi si gen bon jan raison pour arrestation.
So, sir, there's probable cause for the charge, and you are ordered to stay away from the Balenciaga store at 151 Northeast 41st Street in Miami, Florida.
Monsieur gen bon jan raison pour accusation, il faut rester loin à magasin qui est le Balenciaga, qui dans 151 Northeast 41e rue dans Miami, Floride.
So, state, are you okay with a $5,000 bond?
Avocat l'État ou d'accord pour caution $5,000?
That's fine, Judge.
Judge, I don't see any prior record. Would you consider pretrial services?
That's
Ni pa gen
I think-
antécédent, juge, est-ce que tu avais mettre dans le programme qui est les pretrial services là?
I want to say the.
Date?
the
I think it's
codefendant-
okay, Judge. It looks like he's been in the country since at least 2017.
Semble que dans le pays a depuis 2017.
Is he eligible for pretrial?
Est-ce que il est
Pretrial,
capable dans le programme là?
Pretrial services alternate bond, it's $5,000. Have a good day.
Monsieur gen doit dans le programme qui est les pretrial services là ou bien sou pa vle payer caution $5,000.
All right, next we have Dylan Goulart. Thank you so much, Miss Wilson. Au
This is the
revoir.
only Creole. Au revoir, juge.
Yeah. Yes, ma'am. Dylan Goulart, page 15. Good morning, sir. You were arrested for a case from August 28th. The charge is aggravated assault with a deadly weapon. Sir, can you afford to hire a private lawyer?
No,
Do you own your home?
mortgage. I live with my mom.
Is it in your name?
No,
All right, public defender's office is appointed. So let me review. There's probable cause for the charge. Sir, you are ordered to stay away from the alleged victim, Rafael Sanchez Godoy. No contact with the victim. 1 second. Oh, yeah, you're ordered to stay away from Rafael Sanchez Godoy, the alleged victim. No contact with that victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from that victim, their home, school, and place of employment. Your bond is $5,000. Have a good day. Next is Abdias de Rosier. Page 15. Good morning, sir. You were arrested for possession of cocaine, trespass after warning, and possession of cannabis. I will appoint the public defender's office for you. Here's probable cause for the charges. You are ordered to stay away from the Marathon gas station at 3195.
I don't normally interrupt hearings, but Michael just put it in the chat. His Wednesday video hit 10,000, over 10,000 now views. That's a huge deal for Michael and his channel, so everybody please congratulate him in the chat. And well done, Michael. Very happy to see that.
Sorry.
I'm setting a bond. Count one, the possession of cocaine. Will be $1,000. Count two, trespass after warning, is $500, and count three, possession of cannabis. You already won on that, $1 or $1, count three. So stay out of that Marathon gas station. Next is Sean Bethel. Good morning, Mr. Bethel. So you were arrested for strong arm robbery and battery? It's
One
from-
moment, Judge. One moment.
That's not Mr. Bethel? Sorry. Good morning, Mr. Bethel. So you were arrested for strong arm robbery and battery. It's from October 7th of 2023. Sir, can you afford to hire a private lawyer?
No.
I will appoint the public defender's office for you. Are you currently living with the alleged victims? B is Brittany Rose, or the child?
She's here, Judge. I'm not a co-host.
Oh, all right. Now you're a co-host.
Oh, okay.
She was in.
Ma'am, sir, are you currently living with the victim? Do you live with her?
No.
All right, ma'am, raise your right hand and be sworn, please. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
I was only joining because they told me to join to dismiss. Someone called me
Okay.
this morning.
Put your hand down. You promise to tell the truth?
Yeah,
All right, what is your name, please?
Brittany Rouse.
Miss Rouse, are you afraid of Sean Bethel?
No, ma'am.
Do you want the court to order Mr. Bethel to stay away from you?
No, ma'am.
Has anybody forced you or threatened you to come to court today and make this statement?
No, ma'am.
All right, leaving early today, huh? All right. I knew. Okay, thank you. State any questions for Miss Rouse?
No questions.
All right, defense, any questions?
No, Judge, thank
All
you.
right, thank you. And what about the child? Do you want the child to have contact with him?
Yes, I would like her to have contact with her dad.
You what?
I would like for her to have contact with her dad.
Okay. How old's your child?
She's 11 years old.
Okay. It says here 2020, that would be, who's BB?
Yes, Brianna Bethel.
What's her year of birth?
01/29/2014.
Oh, they wrote here 1/2/2020. Is there another child, DB?
No.
And your child's initials are BB?
Yes,
Tell me the date of birth again?
012914.
Thank you.
Welcome.
All right, so, sir, I'm entering a modified stay-away order from the alleged victims, Brentley Rose and the child BB. You are allowed to have contact with these alleged victims. You are prohibited from being physically threatening or violent towards them in any manner whatsoever. So only friendly, nonviolent contact is permitted. Do you understand, sir?
Yes, ma'am.
Also, do not engage in any criminal activity, do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. You understand the modified stay-away order?
Yes, ma'am.
Thank you. All right.
This is dismissed, correct?
No, it's up to the state to decide if they're going to dismiss it or not. It's from 2 years ago.
I'd ask for pretrial services. I see no prior history, Judge.
All right. 1 second, I gotta make my notes. Pretrial services, alternate bond, count 1 will be $2,500, count 2 will be $1,000. Have a good day.
Yes.
Thank you for coming in, ma'am.
Thank
Good luck to
you.
sir. Jose Alanis, page 16. And I guess he has a bail bonds in here. Good morning. Sir, you were arrested for possession of a firearm, weapon, or ammunition by a convicted felon, 3 counts. Another count for possession of a firearm, weapon, or ammunition by a convicted felon, grand theft of a firearm, possession of more than 20 grams of cannabis while armed, armed possession of THC cartridges. So I will appoint the public defender's office for you. Let me review. So in the residence, they found a lot of, let's see, rounds, a gun, a lot of cannabis, THC cartridges, cash. Okay, Ms. Corey, anything you want to say?
Yes, Judge. There's nothing indicating where in the residence these were located.
Nor is it indicating he lives in that residence. I didn't see that either.
No, I don't see anything indicating his personal belongings were there, what room it was in, if it was.
No probable cause unless you want to call up your officer.
We can set it for a PC hearing.
Reset for probable cause hearing. So he does have a bondsman here. But we'll have to reset it though for the afternoon. So
Ms.
come
Corey,
back.
unless you wanna agree to probable cause since he's got the bondsman.
There you go. First, and bring it in. Good morning. 1 second. All right, now we have Osan Altador, page 16. Good morning. So you were arrested for possession of cocaine and unlawful possession of a stolen credit or debit card. I will appoint the public defender's office for you. 1 second.
Some felony bond.
Hold for the division judge. That's on F252482A. You'll see Judge Brinkley on Monday. You got it? Thanks, Mary. So give me a second to review for probable cause. 1 second. There's probable cause for possession of cocaine, $1,000 bond. And on the other case, unlawful possession of a stolen credit or debit card. There's probable cause. $2,500 bond. Have a nice day.
So I put a poll up, kind of a fun one, about what do you think Judge Glazer would want most for Christmas? And I'm surprised that Chipotle gift card didn't do better, considering how hangry she can get. But, you know, I just found it interesting. Let's go back to Judge for a couple more minutes.
Morning, sir. You were arrested for strong arm robbery, criminal mischief over $1,000, and battery. I will appoint the public defender's office for you. There's a victim here on Zoom. Can you raise your hand and let us know you're here, or type your name in? Do you have a place to stay that's not with the victim, sir?
Yes.
All right, thank you.
You know, he also has a hold for Palm Beach County, no bond.
You have a hold for Palm Beach as well.
Oh, what is that hold for CRD?
I don't know. So there's probable cause for strong arm robbery. And let's see. Criminal mischief is a misdemeanor. In battery, there's probable cause.
Judge, I think it was 2 things that were damaged, let's say.
Who is this person you just promoted? Is this the victim?
Yes.
The door handle and the windshield, so it comes to 1,000.
Oh, okay. Ma'am, you want to raise your right hand to be sworn? Do you swear or affirm the testimony you're going to give in this proceeding will be the truth? If so, state I do.
I do.
Thank you. What is your name?
Fanny Lattimore,
Uh-huh. And what is your date of birth?
4/28/89.
State?
Ma'am, why'd you come to court? What do you want to tell the judge?
That I wanted to dismiss the charges. It was a lot. I didn't think it was gonna go. It wasn't supposed to go that far with the statements and those charges. I did not expect that. It was just more so we were in these heated moments, and it was not supposed to be that far. We actually just started a tow trucking company, and I just wanted at that moment away from him. I didn't know that it was going to be like this. I mean, I have the phone that I say that I explained to them that he grabbed, but it wasn't like that. We were in a moment. He's just coming home. I'm not afraid of him. I didn't even go to the hospital or anything. It wasn't that serious. I just wanted to get away. And it wasn't that bad. It wasn't that serious. The damages, I know he can fix. He literally just started his company. I don't want to see this for him. He got to do anger management during his CRD. Maybe if we can start that.
Right, so he was released from prison less than a month ago. He was released from prison on the 18th. I'm sorry, on the 12th of last month.
Yes. And we started the company right before. So I mean, he's trying. It wasn't supposed to be like that. I promise. I have the phone that they're charging him with. It was just a part of the statement that they were asking me questions. They created it that way.
I got you, ma'am.
So, Ms. F, do you have any questions for her besides finding out a statement and hearing all about her relationship with her husband or boyfriend? Oh, okay. Ma'am, are you afraid of Mr. Fisher? Are
No.
you afraid? Do you want the court to order Mr. Fisher to stay away from you?
No.
Thank you. Miss Corey, any questions?
No, Judge, thank you.
Sir, I'm entering a modified stay away order from the alleged victim, Fanny Lattimore. You are allowed to have contact with the alleged victim. You are prohibited from being physically threatening or violent towards her in any manner whatsoever. Do you understand only friendly, nonviolent contact is permitted?
Yes, ma'am. Yes,
Do not, thank you. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. All right, so you understand the modified stay away order, sir?
Yeah, yeah, so
I
much
gotta
of,
set a bond, so there's probable cause for everything.
But I have the phone. Okay, I'm sorry.
I know, there's still
I'm-
probable cause for his arrest and the charges they're bringing against him. I'll set a bond. Count one will be $1,500. Count two will be $150, and count three battery is $500. Total bond is $2,150. Good luck to you both. Have a nice day. Next, we have Cesar Niata, page 17. There's somebody here, a bondsman for Mr. Niata? Sir, do you speak English?
Good man.
Good morning, sir. You were arrested for possession of a controlled substance called THC and possession of a controlled substance called hydrocodone, and also dealing in stolen property. So can you afford to hire an attorney, sir?
Yes.
Do you want to waive the lawyer's presence for purposes of this hearing so I can proceed now and set a bond? Or do you want me to reset it for the afternoon? So you can get a lawyer.
No, I want to get him one, please.
Pardon me?
You want a bond? Is that what you said?
Yes.
He wants to
All
get
right.
one.
Okay, thank you. Let me review. Also, your bondsman is here to get you out. There's probable cause for dealing in stolen property. That bond is $7,500. And in the other case, possession of the THC. He had 3 jars containing THC wax and 2 bags of gummies. Okay. And then he also had, where's the 10 pills of hydrocodone. Count one, the possession of the THC wax is $500 in the gummies. Count two, the possession of the hydrocodone. 1 minute, I just read it. Can I have that back again? No, I have, not that one, never mind. 10 pills of hydrocodone. All right, I'll set that bond on count two at $1,000. Have a nice day.
You too, man. Thank you.
Next, we have Diego Rivera, page 18. Good morning, sir. You were arrested for 6 counts of possession of a controlled substance called THC. I will appoint the public defender's office for you.
Corrections,
Says-
these are added charges.
Yes.
Yeah, I had it added.
You want just one?
was-
What happened to his other case?
He got pretrial, judge. I'd ask for pretrial on this. Apparently he's been
Alright.
pretrial.
All right, pretrial services, alternate bond. Count one is $2,500. Counts 2 through 6 ROR. Have a nice day, sir.
So Judge, we're gonna do 1,000.
Count one is 1,000? Okay.
Yeah, rather than the 2,500.
Pretrial alternate bond, $1,000, count 1, 2 through 6 ROR each count. Have a nice day. Next is Gerardo Gonzalez. Page 18, moving right along. Good morning, sir. You were arrested. Good morning, sir. Do you speak English?
Yes.
Sir,
English.
you were arrested for aggravated assault with a deadly weapon and 1 count of armed threats or extortion. So I will appoint the public defender's office for you. You're out on felony bond. There's a hold for F-25-7703. Public defender's office is appointed. Any argument, Ms. Corey? Yeah, let's see. don't know if that's threats or extortion.
From C
So
count
if you read the end, it
two.
says, demanded the victim exit the store. He threatened if the victim did not come out, he would slash the victim's tires.
That doesn't sound like extortion.
It could
I
be,
think
I
it
guess, threats,
technically
armed
does.
threats. Sir, you are ordered to stay away from Johnny Alvarado, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. And no contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. Also stay away from the barber shop where the victim works at 2485 West Flagler Street in Miami, Florida. Do you understand the stay away order, sir?
I live like a block away.
So just stay out of the barber shop. All right, fine. Stay 50 feet away from the victim, his home, school, and place of employment, and that barber shop. You have a hold. You're gonna see the judge Monday. Count one is $5,000. Count two, armed threats or extortion. I'll set that at 2,500. Have a good day. Next is Derek Lee. Good morning, Mr. Lee. You were arrested for battery by a detainee on another detainee. I will appoint the public defender's office for you. There's probable cause for the charge. Your bond is $2,500. Have a nice day.
Miss F, do you have the name of the alleged victim?
It is Ruben Vivas Marin.
Next we have is John Metzger, page 19.
NBC.
Let me review.
We can waive his presence.
Okay, I'll appoint the public defender's office, waive presence.
I should find no probable cause for a burglary, judge. Does not indicate.
I think it's based upon possession of recently stolen property.
Do you see a date for the actual burglary?
So they found checkbooks that were taken from inside of the vehicle.
I don't see a date.
He has different victims' items. I'll find probable cause for the charge. I'll set his bond at $1,500. You said he refused?
NBC.
Oh, NBC, sorry. Then we have Abelardo Ortuno. Is he here?
No, Judge, he's at Ward D. There's no one available from corrections to get an iPad to him.
All right.
So at this time, we'll go ahead and waive his presence, so at least you can set a bond for him in case someone wants to post a bond.
I'll appoint the public defender's office, waive presence. So let me see, what is he on the end? I found probable cause for everything, I thought.
For count 3, you found probable cause for just possession.
Okay. Let me see what I wrote.
It was 6 pills.
I need that, Renee, I need that because I can't find it here. Page 20. I wrote probable cause for count 1, 2, 4, and 5, 3, no PC. Is it just possession of fentanyl? Yes. Count 3. All right, so count 1, Count one, there's probable cause for the charge, that's $7,500. Count two, I'm sorry, I'm gonna split one and two. Count one is $5,000, sorry. Count two is $2,500. Count three is $2,500. Oh, and that's part of count four is also the fentanyl, right? Methamphetamine. Count four is $1,000. And count five be $500. So 5,000, 2,500, 2,500, 1,000, and 500.
Your Honor, is that with the Nebbia?
No Nebbia. He's free to bond out if he wants.
We finished before noon.
We're done. We're lucky we did.
Just on time.
We'll see everybody at 1:30. Enjoy your lunch.
Thank you, Anna. You too.
Thank you.
Applause all around. She made it to lunchtime on time and did not freak out. It's a good day. Good day for Judge Glazer. Let's go back to Judge Wolf. The opposite of freaking out.
Mr. Stewart, you're here to be arraigned on an indictment charging you with theft of property with a value of $10,000 to $60,000, a Class C felony. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
The public defender's office is here. They will be appointed to represent you. All right, public defender's office has a conflict, so we will appoint Mr. Nathan Brown, who is not here at the moment, but I don't think.
What's the conflict?
Conflict is that they may represent one of the other defendants, or they may have represented one of the victims in the case or had some conflict in that way. They're not necessarily required to tell me what their conflict is, but the Code of Professional Responsibility requires them to advise me if they have a conflict that would prevent them from being able to ethically represent you. For example, you want a lawyer whose only concern is your best interest. You don't want a lawyer who's torn between whether this is going to benefit you or their other client. That's the whole idea behind a conflict of interest. So we're going to appoint Mr. Nathan Brown, who does not have that conflict. And standing in for Mr. Brown, would you, Mr. Talbot, please, for the indictment, for the arraignment?
Thank you, Your Honor. I acknowledge receiving a copy of the indictment, waive formal reading of the same, and on behalf of the defendant and on his attorney, enter a plea of not guilty.
All right. Plea of not guilty is entered. General Wojnarowski, we're going to set this for January the 7th of 2026. Mr. Brown is going to be given a copy of these charges. He'll be up to talk with you as soon as he can arrange it and get you ready for either a disposition by an agreement at some point, or if you cannot resolve it by an agreement, then on January the 7th, I will set you a trial date.
All right.
All right, thank you. He'll be up to talk with you as soon as he can.
While he's between contestants, I would like to point out that at 1 p.m. Eastern, 10 a.m. Pacific, so an hour after 11 a.m. and 2. I'm so confused. 2 p.m. Eastern, 11 a.m. Pacific. There we go. An hour after this show ends is the bottom line. There's a video going up with Judge Wolf on this channel that's incredibly interesting. It's a custody dispute. We've got a father who didn't realize he had a son, found out he has a son, who has special needs, and he is alleging severe neglect, and he is fighting for full custody of this child that he did not know he had. So super interesting hearing, and you want to give that a look. Back to Judge.
Does the public defender know of any conflict you would have in this case? All right, public defender has a conflict. We will appoint Mr. Jacob Finley of the Clarksville Bar, Montgomery County Bar. He'll be notified of his appointment and be in to talk with you. You wish to stand in for him for arraignment?
Yes, sir.
Hand that to him.
Your Honor, I acknowledge receiving a copy of the indictment and waive formal reading of the same, and on behalf of the defendant and his attorney, enter a plea of not guilty.
Plea of not guilty is entered. We'll set it for status on January the 7th. That means your lawyer will be up to talk with you and see if he can get you, we have to advise him of his appointment, and then he will may need to make arrangements to come talk with you. And then once he has been able to talk with you, we will see if it's able to be resolved by an agreement. If not, on January the 7th of 2026, I will set you a trial date. So they'll be up to talk with you.
All right, thank you, sir.
Good morning. What is your name?
Larry Tanksley.
Larry Tanksley. Mr.
Yes,
Tanksley
sir.
will be arraigned on a charge of assault with bodily injury and theft. You have a lawyer named Roger Wainick that represents you. Is that correct?
Yes, sir.
All right. Mr. Wainick, has he filed a waiver? All right. Mr. Wainick is apparently in transit somewhere, so we'll allow that. Let's go ahead and stand in for arraignment. Since you have a lawyer, do you wish to have a formal reading of this indictment?
No, sir.
All right. Standing in for Mr. Wainick, the Public Defender's Office has waived the formal reading of the indictment, entered a plea of not guilty. General Sylvie, how do you wish to handle this scheduling?
Your Honor, if you want to go ahead and set it for a trial date.
All right. You want to set it for trial in January?
We'll go ahead and do that. That'll give Mr. Wayne time to get discovery. Do that. So we could set it for trial in January with.
Well, that judge in January may not agree to that because of the fact that that's contrary to his scheduling order.
Well,
I don't know. Yeah, he can be difficult to get along with sometimes, and I've heard, so do you...
I defer to the court then.
No.
Set it how...
To stay consistent with it, then we'll set it for January the 7th for status, and if you don't resolve it on that day, we'll give you a trial date. So,
Okay.
as many days as we might have in January, we might be able to even try it in January, but I'd rather just put it for status right now. My rule is that, as you know, under this new process that I'm following, once we set it for trial, it goes to trial or they plead to the indictment and go to sentencing. So that's why I don't want to set it for trial in front of me unless.
That status date will be.
Right. Thank you. I know you want to stay on good terms with that judge anyway, so. Mr. Tanksley, your lawyer will be advised of the fact that we're setting you for January. We just lost the jail, so. While we're trying to get the reclaim the jails video, I'll go back to calling the regular docket. So, do we ever find out whether or not Mr. Cameron is 1 o'clock? All right. 2025 CR 77 State versus William Grant Darden. All right, I'll put it on the second call. 2023 CR 336 State versus Gregory Arnie Hansard III.
Well, that contestant comes up, just an FYI for everybody. It does not look like we're going to have dungeon court today. As of now, they are not in session. So, just an FYI.
Motion to continue. Is there any opposition to the motion?
No, sir.
All right, do we need to go ahead and schedule for this month the 412 motion?
I've spoken
Is this
with,
the one where she's,
she just had the baby.
Okay.
Yes, sir. She stated that she's comfortable moving forward this afternoon with the 412, but for the trial, I think testifying about the actual event, she could not do. So we could do the 412 if the court would like to hear that today. I understand. Listen, it was motion to continue the trial, I think specifically is what I know
there's a lawyer's, when a lawyer comes in from a hard day in court and he sits behind his desk, and then the secretary comes in and says, do you want to talk to so-and-so client on the phone? I always used to say, that's the wrong question. Not do I want to talk to that person, but will I talk to that person? So when you ask me, do I want to do the 412 motion, it is not a question of whether I want to do the 412 motion. It's a question of whether I will do it.
Yes, sir.
We have another sentencing hearing that's set for this afternoon.
Okay.
I'm just wondering, we also have we have the 26th of this month. Is there anything set besides Curtis Day? I have a Curtis Day second-degree murder case that Mr. Atchison is involved in, and it's set for sentencing here in this courtroom on the 26th. So I'm just wondering if that might be a better day. We don't have anything else set for that day, right?
The 26th is fine.
All right, let's set it for that morning at 9 o'clock. I think we'll do the Curtis Day, and then we can take this one up.
Okay, all right.
All right, so this one is Mr. Hansard's 412 motion. Is that the only thing that we'll be dealing with on that day?
Yes, sir.
Yes, sir.
Do we want to go ahead and set a trial date today, or would you like to get one?
I mean, that's fine. We can set a trial date. If you want to set one in January, then it might be the most appropriate.
Yes, sir.
We have given you trial dates. The conspiracy case, General, is still set for the 20th through the 23rd, correct? Is this a case, Mr. Hansard's case, one that we know for sure will go, and how long will it take to try it?
I think maybe a day and a half. I think it would depend on how long jury selection.
And I think 2 full days, Your Honor, is my.
2 full days?
Just to be safe.
Yes, sir.
What about the 29th and 30th? I mean, we've got stuff set. That's the reason I don't want to set anything unless it's for sure going to go to trial. Right now, I've got the 13th. Greer. Sheets on the 14th. But if it's a 2-day trial, I don't want to set this one. So then we start the conspiracy case on the 20th, and it's going to go the whole week, correct? Are we trying it at some other venue? Are we trying it down in the jury assembly room where we can get all of the defendants in one location? Or are we looking for a gymnasium somewhere? In January, a football field will be a little bit dicey, I think. So, all right, well, why don't we just set this one? And let me just ask this. If I assign a trial date, everybody understands it's going to trial or he's pleading to every count of the indictment and going to sentencing. So with that, you understand that, Mr. Talbot? I will set it for January the 29th and 30th. All right.
And then the motion.
Motion for 412 will be this month on the 26th.
26th. Thank you, Your Honor.
9 o'clock in the morning.
Yes, sir.
Yes, sir.
Okay.
All right, I'm sorry. Going back to you at the jail, we have appointed, let's see, who was this I was dealing with? Mr. Wainick is here, lawyer. Thank you. I'm trying to remember what, okay, we set it for status on January the 7th, and your lawyer will be up to talk with you and try to get you ready for either a disposition or a trial date will be assigned on January 7th. So Mr. Wainick will be up there to talk to you as soon as he's back in town. All right. I guess I could just tell him to talk to the other Roger Wainick there at the jail. Good morning. What is your name, please? You're muted. You'll have to unmute that device again. There's wherever the little microphone is, it's got a slash through it. Just punch on that.
There you go. All right, Dudley.
What is your name?
Jack Dudley.
All right, Mr. Dudley, you're here to be arraigned on a charge of probation. It's an amended charge of probation violation, and you've already got the public defender, so we'll appoint the public defender on this charge as well.
Your Honor, I acknowledge receiving a copy of the warrant and waive formal reading of the same and enter a plea of not guilty on behalf of the defendant.
This is presently set for October the 27th. Do you want to set this one as well?
Yes.
All right, October 27th. Your lawyer will be up to get you ready for that hearing. Thank you.
Thank you, Your Honor.
Please.
Good morning. What is your name?
Rubén Barrientos.
All right, Mr. Barrientos, ¿se habla inglés? No?
No, señor.
We'll need to get an interpreter.
Entiendo un poquito, pero es muy difícil.
Poquito español por moi is French.
Usted también habla un poquito español.
I am poquito español.
Bueno.
We're going to set let's put it on the regular arraignment day and make sure we have an interpreter. We're going to get an interpreter for Espanol, and we'll reset you for the 22nd, September 22nd, 9:22. Gracias.
Gracias.
And that is the extent of my Spanish.
Right there. Did you see him?
Yeah.
You talked to him?
Yes.
Said, oh, they reset it? Hey, just a minute, I'm gonna go get your females.
All right.
I said, just a minute, sir, I'm gonna go get your females.
All right, thank you.
All right, well they go get him some females up there in Tennessee. I love this court. I really do. You know, it's never over the top, but it's interesting. There's very good respect. You know, even the guy who's, you know, the defendant right there is trying to communicate, and he's laughing about the fact that they're trying, and it's just good. So while we wait for them there females, let's go back to Michigan. We'll do a hearing with Judge Elmore, and then we'll probably come back for the females.
8th Circuit Court here in Westford County. And we're going to begin today's docket call by taking up the case of People of the State of Michigan versus Joshua Johnson. This is case number 25-14115 FH. Appearances, please.
Joanne Carey for the people.
Dodge on behalf of Joshua Johnson. And Mr. Johnson is currently in pretrial custody and has been brought here in the courtroom and is now seated next to counsel. We're here today for a pretrial conference, which is a court-ordered opportunity for the parties in the court to meet to figure out what's going on with the case. I conducted that pretrial conference in chambers a little while ago this morning with counsel. We understand that there is no resolution at this time. I should have asked you, Mr. Dodge, are you getting discovery? Any issues I need to be made aware of? No,
No issues, John. We've got good communication with the prosecutor's office getting discovery.
great, thank you. I've called the case on the record because Mr. Dodge wished to make a motion regarding bond. There is a written motion in the file. I have read that. I know the people have not submitted a response to that, but that's all right. Talk about it in chambers. Mr. Johnson, and I understand, by the way, that there's another similar case pending over in Manistee County, which is where the defendant resides. All right, Mr. Johnson, the floor is yours. I'm sorry, Mr. Dodge, the floor is yours. Thank you.
Thank you, Your Honor. And as the court acknowledged, we did have the opportunity to file a written motion and with several bullets with components of the case here. But the bond in this matter originally set at $150,000 cash or surety by the district court. Our request is that the court consider reducing that bond somewhere in the range of what was set in Manistee on similar charges, $15,000, and we would ask for a 10% bond if possible, and that's mostly for the benefit of Mr. Johnson's grandmother, who's in court today, who would likely be posting that bond. I think I'm not going to guess on the bond being set at $150,000 because I was not part of that, and I did not set that. But one very serious loose end out there was that there may be a Manistee County charge. That was out there for a while, and now that has been obviously charged and bond set on that matter. So we're asking that the court somewhat follow suit there. There was also an added condition of GPS tethering, because obviously these are serious allegations here. I've already reached out to the Manistee County District Court Probation Office and getting what we need on getting Mr. Johnson on GPS tethering if he were to be bonded out. No prior criminal conviction history is noted, serious charges is noted, but GPS tethering, no contact with individuals under the age of 18. That would keep the court. As indicated here, this was a pending investigation back in June, and Mr. Johnson was made aware of that, both to the Michigan State Police. He was made aware of the allegations, and there was no attempt to flee or evade whatsoever. Johnny continued to maintain employment, and so we asked that the court to consider that as well, as far as that he's not going to evade, he's going to appear for court. He does have gainful employment with actually a couple of potential different employers here, and he would be released to the home of his grandmother, Mrs. Laura Johnson, who's in court today. Taking this matter extremely serious. I've had a lot of communication with her, and if Josh is released here, he will be in a good structured setting and doing productive things such as employment. And Your Honor, I would also, on cases of this variety, which is the norm, perhaps have Mr. Johnson look into some resources to explore some of these allegations here, all things that the court would think are appropriate. So we would like to get him involved in some of those resources as well. Any other questions, Your Honor, I'm happy to answer. Thank you.
Thank you very much, Mr. Dodge. Ms. Carey, on behalf of the people.
Thank you. It's interesting to me the differences in the bond in both courts. However, this case is serious. This criminal sexual conduct, 3rd degree with a child who reported feeling scared and ashamed and afraid of the defendant. And it's concerning that he has similar charges, although more of them in another county as well. Understand that he does not have a criminal history, but the nature of this offense and the offenses in Manistee County are very, very concerning. We don't have really any information on his mental condition, but I would say the reputation for dangerousness, given that he is, the victims in this case are underage, is serious and should be taken seriously. The seriousness of this offense, it's a 15-year felony and it involves children, so that is of concern. Read the motion where I understand his employer may be willing to take it back or is willing to take it back, which is encouraging, and that he's got some family and he's been in this area a long time. However, again, the very serious nature of these allegations and the fact that there are more allegations pending raise a lot of concern for the people, and the people would ask that if the court does lower the bond, we're going to ask that you not lower the bond, but if you do lower the bond, that it not be 15%, that it not be 10% and more than the Manistee bond of $15,000. Thank you.
All right, thank you. Mr. Dodge, you mentioned possible treatment things. Ms. Carey said that we don't have any information about its mental health. So is there anything there that we didn't cover that I need to know about? Is he in treatment? Is he on any medications? The reason for asking is because then I would order that he continue to be compliant with that treatment. Do we know if there's anything like that?
There has not been any of that thus far, Your Honor, but I often on a case of charge this Friday, there's a couple of well-credentialed entities that do risks assessments, things like that, and obviously I know of the client's grandmother here, that's going to be done here and it's
Mr. Dodge, are there any other children or people that reside with grandmother other than grandmother and the defendant? Anybody who's under the age of 16 is what I'm thinking.
Your Honor, it would just be those two.
Okay, thank you. And do you know when does your client typically work? What's his typical work schedule?
It would normally be first shift duties would be my understanding, but whatever.
What do you do, and what do you define that as, sir? What time do you go to work?
I leave my house at 6.
Okay.
Be at work at 7.
All right.
Usually work till 5 or 6 o'clock at night.
All right. All right.
The potential employers are aware of this.
Yep, I saw the letter.
Whatever you would say that they would comply with.
All right, thank you. All right, the court begins its response here pursuant to the court rule 6.106. Number one, it's often misunderstood by people who are not here in the court system whenever we talk about bond in a case. People tend to respond and jump to the conclusion that there is guilt. And therefore, how could anybody with these allegations be released on bond? However, the law says, and I believe that anyone who believes and supports the Constitution says that a person is presumed innocent until otherwise proven guilty. And the law itself says that bond is not to be used as a punishment. Bond is to be used to ensure the appearance of the defendant at the trials and court hearings, to also ensure protection of society. And the court is to use that are reasonable. And there can be no presumption here of that, I'm sorry, application of bond conditions that would be a punishment. Court recognizes here that the defendant does not have any prior convictions, is relatively young. I think he's 24. Thank you. He has had employment. There are other things about the case that we talked a little bit about in chambers that do not need to be discussed here today on the record. The court will modify the bond as follows. The court will reduce the bond to a $15,000 cash surety or 10% bond. The court will, in addition to the standard terms and conditions that the defendant is not to leave the state and not to commit any other criminal activity, the court continues the term or condition that there is no contact with the complainant. Most people would say the alleged victim. Either way, I know the initials are ST. The court will continue that, although I'm going to change it. The defendant is to all right, I'm going to add to it. The court will continue he is not to have any unsupervised contact with anyone who is under the age of 16 years of age. The court is also going to add that the defendant is not to have any unsupervised communication with anyone under the age of 16. Now, what I want is obviously if the defendant engages with people who are at his workplace, that's supervised, that's fine. But what I don't want is to have any communication with such as internet, social media, so forth. Now, there is this one here about not having access to the internet. Well, that one I really can't monitor. I understand why it's placed on there or why it was placed on there by the district court. But that one's quite difficult to monitor. Plus, still has the right, the First Amendment right to have communications with people of his own age or people who are not under the age of 16. So I'm going to remove that one. I will continue not to have or possess any firearms or weapons. And I will add to it, the defendant is to be placed upon a tether for monitoring purposes. Now, if he's placed on a tether by one county, then clearly we're not going to put two tethers on him and charge him twice the money, but I'm going to require until this case is resolved that he's placed on tether. If that's done through Manistee County, that's fine. If for some reason the Manistee County case resolves, and this case has it, got to get the tether continue to be put on. The court is going to add a curfew. That curfew will be from, he has to be at the residence where grandmother lives. Is that the address that he has here on 13 Mile Road over in Manistee County?
Yes.
Yeah, all right. He has to be at that residence, and I'm going to say between 9 p.m. and 5 a.m. That allows him enough time to get to work, get home from work, run any other kind of appointments or anything that he needs. All right. Now, if for some reason, Mr. Johnson, you need to have some, I don't know, some appointment or some counseling session, don't go to that counseling if it's beyond those curfews unless you communicate with the people at our community corrections office. Does that make sense? Yeah. So where it's reasonable, but what I'm trying to tell you is don't ask for permission, don't ask for forgiveness. The court's going to order that the defendant either continue his employment, and if he is not employed through the current employer that we've talked about today, he must continue to seek employment. All right, I think I covered it. All right, that's it. Madam Clerk, did you get all that? Thank you. Anything further today, Ms. Carey?
No, thank you.
Anything further today, Mr. Dodge?
No, thank you, Your Honor.
Okay, now there is one thing I want to make sure that Mr. Dodge knows, because he hasn't been here before, and that Mr. Johnson understands. When we get to final pretrial conferences, now, first of all, whenever I talk about a final pretrial conference, I should make air quotes. Because what we do is we'll have a trial date, and then 10 days before that on a Friday, I'll have every case that could go to trial on that Tuesday, 10 days later. They all come here for a final pretrial. Now, obviously, I can't do more than one trial, but on that final pretrial date, I tell the defendant today is the last day that you can enter a plea pursuant to a pretrial agreement. Now, if for some reason, if I end up with let's say I've got 5 cases that come here for a final pretrial and 3 settle or whatever, and I've got 2, they're both going to be scheduled for trial on that Tuesday because I don't want to lose a trial date. But the one that doesn't actually go to trial will have to come back for another final. But here's what's important. At final pretrial conferences, again, as I just said, I tell a client that, or a defendant, that it's the last day. Meaning, if you come to trial date and you didn't settle it on the final pretrial date, then you're going to trial or the person can plead as charged. Now, there's a reason why I do that. It is not to compel a person to plead guilty or to compel somebody to take a pretrial agreement. In fact, it has really nothing to do with the defendant. I want the defendant to know if that case doesn't settle and their case goes to trial on that Tuesday, that defendant walks out of here and knows he's got the best offer I could have ever gotten. That's it. But it's also really to make sure the 2 attorneys have exhausted all of their negotiating skills. It makes the prosecutor give the best deal that he or she could give, and it gives the defense counsel an idea, okay, and it ain't gonna get any better because the judge won't let it. And it's also really to do this. When we have a trial, and in a case like this, I'm gonna have to bring in about 120 potential jurors. Of that 120, about 30 won't show. But then we'll have to issue subpoenas to have them brought in for potential contempt. But all those people have to take time off of work, get babysitters for children, get somebody to take grandma to the hospital, do whatever, to get somebody to substitute for them at work. And then the prosecutor's got to get witnesses, and they all have to take off time from work to be here. Your defense attorney has to do the same thing for any witnesses. So before we start that system working, you and everyone needs to know, we have exhausted all of our negotiating skills. Okay, so it's never to force you to do anything or a defendant. It's really to force the attorneys to have exhausted all those skills. Does that make sense? Now, again, we're not up until that date, but I just want you to know, and Mr. Dodge to understand, that's how I operate. And there's a reason behind it. It has nothing to do really with you. It has to do with them. All right. I think I've got it covered. Thank you very much. We are adjourned.
Okay, folks, looks like they wrestled up some females for Judge Wolf, so let's go back there.
My 84-year-old client is at a doctor's appointment that he could not reschedule today, so I will follow on that sword.
So your 84-year-old client is charged with aggravated assault, is that correct?
He sure is, Judge.
All right. So what do you want to do with him? You want to put him on status on the 22nd?
Is it 20, that's fine.
Whatever you want to do. I don't care.
9/29 sounds a lot better than horrendous.
September the 29th. Thank you.
Thank you, Judge.
All right. All right, at the jail, can you tell me what your name is, please?
Amanda Roberts.
Amanda Roberts on page 1. Ms. Roberts, you're here to be arraigned on a charge of aggravated burglary of a habitation, theft of property, falsely representing yourself as Roger Wanick, that's a neat trick, and financial exploitation of an elderly or vulnerable person and criminal information.
Yes, sir.
You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
I'll have to appoint a lawyer to represent you, and I'm going to appoint Mr. Philip Massengill. His office is in Nashville, but he's here on a regular basis, and I will appoint him to represent you. Let's ask if I could, Mr. Atchison, do you mind standing in for Mr. Massengill? I'm going to have a lawyer stand in for arraignment for Mr. Massengill, who's not here today at the moment. You wish a formal reading of the indictment?
Judge, we waive formal reading of the indictment, and on behalf of Ms. Roberts and Mr. Massengill, we would enter a plea of not guilty at this time.
Plea of not guilty is entered. I believe we've set it for status for January the 7th of 2026. Your lawyer will be notified of his appointment. He'll make an appointment to come see you as quickly as he can, and he will work on trying to get your case ready for a trial or for a disposition. On January the 7th is your final day to try to resolve it by an agreement, and if you have not worked it out by that day, I will give you a trial date. Okay? I thought for a moment she was just so entranced by my words that she was unable to speak or do anything, but I think we're frozen at the jail, so.
Thank you, Judge.
All right, let me go back to calling these other cases. Let's try this one. 2024 CR2, State versus Jeffrey Ty Hicks.
Judge, that is one of Mr. Baker's clients, and we have a motion. We'd actually previously given it a date along with Mr. Flanagan's client, Mr. Long. We had given it an October 7th motion date in Waverly. You had asked if we could move it up till today, and the officer that conducted this traffic stop is no longer in law enforcement. He's working, owning his own company, and he was not able to get work covered for today. So I'm asking if we could move it back to that October 7th date where we originally had it in Waverly at 1:30.
All right, October 7th at 1:30 in Humphreys County. So this motion will be after that. Is there a better day that we could choose other than that? Could we not do it on the 26th of this month? That's when I've set the Curtis Day and the Hansard Rule 412, and we can do your motions after lunch.
Maybe I'll reach out to my officer.
Mr. Flanagan, what about you, the 26th? That's what I'm talking about. We have these other things in the morning. That might be better than trying to do this one in Waverly. If we could check with your officer, we'll come back to it, okay?
Thank you.
I'm sorry, at the jail, could you have your device unmuted again? This is Ms. Roberts, correct? Ms. Roberts, we've appointed a lawyer to represent you named Philip Massengill. He's going to be notified of his appointment. He'll be up to talk with you. And we've set you for January the 7th as your final day to resolve it by an agreement. If you don't work it out by that day, I'll set you a trial date. So. Did you hear all of that? Apparently not. Ms. Roberts, can you hear me? At the jail, we need to communicate with the jail, let them know that apparently they're not able to hear. Modern technology. I cannot hear you, and I'm not sure you can hear me. Can you hear me?
They're buffering or something. You can't hardly hear them.
Yeah.
Now we can hear
I don't know
you.
why this is off.
Apparently not.
Well, he's got you muted. See that X? He's got his side muted where you can't hear him.
All right. Let's try to muddle through the. Mr. Flanagan, the Justin J. Long, is that the case we were just talking about? Okay.
22. Mr. Darden, the agreement is that it be dismissed upon payment of restitution in the court costs. So Monday, I want you to contact the clerk's office and get that figure.
So you want to put it on what day?
10/22.
October the 22nd?
Yes.
All right.
Get all that done.
There you go. They were hearing another case, that's why.
Thank you. Ms. Roberts, can you hear me?
Yes, sir.
Let's talk quickly before we lose you again. I have appointed Philip Massengill as your lawyer. He'll be up to talk with you as soon as he can schedule it. And I've given you a date of January the 7th as your last day to enter a plea if you work it out by an agreement. And if you don't, I will give you a trial date on that day, okay?
Yes, sir.
Wait for your lawyer to come talk with you. Philip Massengill is his name.
Okay, thank you very much.
Good? Okay. Come on.
Good morning. What is your name, please?
Kami Lewis.
Jimmy Lewis is on page. Your lawyer, Mr. Lockhart, has had a death in his family, and as a result, we are going to move you to September the 22nd. And hopefully on that day, it can be worked out and everything can be taken care of on that day, September 22nd.
Thank you.
All right, thank you.
Come on, Dudley.
This is what I'm gonna
Good morning. What is your name?
Randy Dillard.
Ms. Dillard is on page 4. All right, Ms. Dillard, you're here to be arraigned on a charge of possession of contraband inside a penal facility or institution, possession of methamphetamine and public intoxication. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Public defender?
Yes, please.
I've appointed the public defender's office to represent you.
Your Honor, I acknowledge receiving a copy of the indictment. I waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. General Bryson? We're going to set this for January the 7th for your final day to enter a plea. If you're able to work it out by an agreement, then we can take it up earlier than that day, but that will be your last day. After that day, we'll set you a trial date. The public defender will be up to talk with you as quickly as they can arrange to see what they can do about getting your case resolved. Okay?
Yes, sir.
All right, thank you.
All right, Zoom is trying to shut it down.
Looking at page 11, State of Tennessee versus Mackenzie Brook Lion Meadows.
That's for plea, Judge.
All right.
Approaching the podium with me. Your Honor, in this case, subject to the court's approval, Ms. Meadows will enter a plea of a plea of guilty, Your Honor, excuse me. She'll enter a plea of guilty to the charged offense in this indictment of 1 count. The punishment on that, Your Honor, will be 2 years of probation pursuant to judicial diversion. She will be required to complete anger management and parenting classes as a condition of probation. She'll be responsible for the court costs. She has signed a plea sheet to this effect, Your Honor, and there are pretrial jail credits on here, and there is a certification of her diversion eligibility as well.
All right. Ms. Meadows, raise your right hand. Let's place you under oath.
I do.
Thank you. State your full name for the record.
Mackenzie Brook Meadows.
Ms. Meadows, you're here today charged with a single count of an indictment of child abuse or neglect. Have you seen or been shown a copy of those charges? Talked them over with Mr. Talbot. You and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter this plea of guilty. Do you understand that you can plead not guilty and have a speedy and public trial by jury in this court?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by using a subpoena. You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. Now, I'm going to ask you to speak up a little bit. The lady in front of me is taking down everything that's being said, and she's recording it. So it's important we get a verbal response. You understand that if you went to trial, I'm sorry, I may be repeating myself, but if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal. Do you understand that?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal, and all I'm going to do is approve what your lawyers worked out?
Yes, sir.
You understand that's we're going to talk about this. You're entering this plea under a specific statute for first offenders, people who have never been convicted or in trouble before. What that means is that you're going to be placed on probation for 2 years. If you successfully complete that probation, don't violate any of the terms and do everything that's required of you, then you can apply to have your record expunged at the end of that 2-year period. That means to wipe this off your record as though it never occurred. By contrast, if you violate the terms of your record, of your probation, this will become a permanent conviction on your record and will be there in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. Do you understand that?
Yes, sir.
Do you understand everything I've explained to you thus far?
Yes, sir.
You want to plead guilty and waive your right to a trial and to an appeal.
Yes, sir.
Do you understand that if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you have been lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
Yes, sir.
You understand I can't accept your plea unless I'm satisfied you are in fact guilty and there are facts to support it. General, are you going to supply the facts for me, or?
Judge, I can supply the facts.
All right, I want you to listen then, Ms. Meadows, as the state tells me what their evidence would be at trial. Please go ahead.
Judge, law enforcement received a report in August of 2023 of an 11-month-old infant that had bruising about her body that was not consistent with normal child play or accidents. Through their investigation, they determined that the baby was in the care of the defendant at an in-home daycare that she cared for alongside her other children. And those are the basis for these charges that did occur in Dixon County. Judge, I would also like to let the court know that the victim's mother is present in the courtroom and has provided a victim impact statement for me to read on behalf of the family.
All right. Then I'm not asking that you necessarily agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to enter this plea according to this agreement?
Yes.
Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Talbot has done a good job of representing you competently?
Yes.
Mr. Talbot, do you know of any reason she should not enter this plea?
No, sir.
Then I will ask you to step back and have a seat so I can hear from the victim's impact statement. General?
My name is Alicia Crouch. I am the mother of Blakely Crouch, who was harmed before her first birthday, a time when she was too young to speak for herself or to defend her little body. No infant should ever have to endure harm, especially from someone entrusted with their care. The impact this crime has had on me as a mother is something I carry every single day. My trust, my peace, and my sense of security were ripped away. Emotionally, I live in constant fear that this could happen again, whether it be starting a new daycare, preschool, or kindergarten. That fear is something I will carry for a long time. At the time of the crime, it was especially hard for Blakely. She struggled with eating, taking bottles, and being away from people who made her feel safe. The aftermath was overwhelming. I had to take time off work to ensure she was cared for and to find a safe place for her. We attended follow-up appointments with her doctor and with child services. Even once I found a safe daycare, the challenges continued. Blakely did not trust the staff. She screamed for weeks before she was finally able to adjust. Blakely just turned 3. She is a smart, beautiful, energetic, funny, and loving toddler with a bubbly personality. I pray that she grows up with no memory of what was done to her, but as her mother, I will never forget the harm that was caused to my sweet Blake. Despite everything, I hope the defendant uses the resources provided by this court to reflect, learn, and do better. What was done cannot be undone, but what one chooses to do moving forward is within their control. My hope is for accountability, integrity, growth, and genuine change. The crime has left a permanent scar on my family. Thank you for giving me a chance to speak for myself and for Blakely today.
General, it's my understanding then that the victim, the mother of the victim in this case is in agreement with this disposition?
Yes, Judge. We met with her and with support persons to explain the process, going through everything, and we reached this settlement agreement together.
All right. Mr. Talbot, you and your client come back to the podium, please. Ms. Meadows, you've heard the very articulate and intelligent victim statement that was, a powerful statement that was given by the victim's mother in this case. You still wish to enter this plea?
Sir.
You've heard her basically state that she hopes that you utilize this as an opportunity for you to reflect and to try to improve your situation and to make sure that nothing like this ever happens again. You understand that?
Yes, sir.
You understand that if you violate the terms of this probation, then you will not only have a conviction, but you will serve 2 years in prison as a result of this. You understand all of that? All right, then Mackenzie Meadows in docket number 2024 CR 230, upon your plea under 4035-313 to the offense of child abuse or neglect or endangerment, order that you be placed on probation for a period of 2 years. And the conditions of that probation are that you must complete an anger management and the parenting classes. You must pay the court costs. As a judgment of the court, you'll need to see the probation department.
Thank you, Your Honor.
All right, friends, we leave it there for this week. Shorter week since we didn't do anything on Monday, but a good week overall and a great day today. Started out with Bo on the pre-show, joining us from Australia and talking about some of their laws down there. That was very enjoyable. If you are not a member, not joining us on the pre-show, you need to fix that because we have a lot of fun there. And a good day in court today, too. So overall, I liked it today. And thank you all for your generosity, too. 38 gifted memberships today. Very kind of you. It just exposes more and more people to what we do here, and I very much appreciate it. And if you're a new member out there, congratulations on that. We'll be back tomorrow, 8 p.m. Eastern, 5 p.m. Pacific for game night. I believe we're going back to Lego Star Wars since we finished Candleman, which ended sadly. I'm going to have to look at the DLC for that one because it needs a better ending than what we got. But we'll be back tomorrow for that. And then Monday, 10 a.m. Eastern, 7 a.m. Pacific for this show, a half an hour earlier for channel members. But until the next time I see you, go have yourselves a great day and a great weekend. Take care. God bless.